Yes.
Item T1. Yeah. For orders. Those two matters your lordship has heard in one. But there is one connected matter which will also be required to be heard together because any order passed this will also have a bearing on the outcome of other matter. So I pray that we tag today or it as part of the convenience of this. If it is tagged,
Filed by the same petitioner.
same because what has happened, the promotion, they want to take away my promotion. And I have challenged that promotion order because when the promotion was made, prior to that, there was a departmental proceeding pending.
All right. We'll connect it whether 50-51. When it has to be in July only or August. 50-51 be listed on 20 July along with WPC.
WPC number 5818 of 2021.
5818 of 2021 has been submitted that the same petition, the connected petition, and be required to be heard together. List accordingly.
Mr. Gugoi, because I
it is submitted that Standing Council Forest has also been.
No, I have to inform.
Who's for Forest? Why did you not inform?
No, but I thought that you picked up today.
No, but you said this matter has to be heard together with some other matter which is not listed.
But normally it comes in the production list. I thought that it will come in the production.
So you wanted a hearing unlisted.
That's not coming in the production. But we'll inform that Mr. Gugoi is very accommodating.
All right.
Pleasure.
With your lordship's permission, my lord. I'm mentioning about item number 45, my lord. Sir, can I pray that this matter be taken as the top of the hearing list today, my lord? I had made the mention the other day, lordship had given.
45.
Yes, 45.
All right. And it. When was it filed? When was it filed? Why not? Why tomorrow? Why not on Monday? All right, tomorrow.
Okay, please, lordship. Lordship, I am paying for this thing. Content matter. It's come in the order column, lord. It comes in order column, lordship.
Order column.
Yeah, lord.
19th June.
Highly
July. When was it last listed? We wanted the petitioner to grow a little older before the matter is to be heard. October 25, it was last listed. You are mentioning it in June. Why? Why is there no concern for the age of the petitioner? What were you doing? Then how is it possible it mentioned and not listed? 18th.
Lordship, I beg to mention item 46, hearing list.
46.
Yes, Lordship, 46. The matter was listed every time, Lordship, but not heard. So I'm praying for upgradation at 2.
Why?
Lordship, urgency is that in this matter, the petitioner was compulsory retirement punishment was compulsory.
So the 24 matter it will be heard in its own turn. Why
Lordship, the
upgradation?
petitioner will be retired on 2020.
What do you mean retired? You are already compulsory retired?
Lordship, actually, the petitioner was given without appointing the presenting officer, Lordship. That is the fault.
What is the punishment?
Compulsory retirement.
Why is the question of petitioner is retiring on so and so day? No upgradation. Why? July. 15 July. Yes.
The matter.
Let it come in July.
Your lordship, the matter pertains to the appointment of an Asha Karmi, your lordship.
Let it be in July. 17 July. July. For hearing, let it come for orders on 17 July. 17 July. Yes. July. Why? What is the subject matter? You want listing for admission. When was it last listed? What is the urgency? Dismissal matter. Huh? Suspension. Don't know. 19th June.
My lord, I recommend for listing a matter, my lord, impleadment petition, my lord, I have filed, my lord.
Impleadment petition.
Yes.
17 June. Item 7. I can't hear you properly. You have to be louder. I am not able to understand. Yes.
You filed the reply,
You want to file.
reply. We have
Reply
received
affidavit you filed or you want to file?
reply.
What is your prayer?
Lordship, 2 weeks of time to
All right. Which item?
item 7.
7. On the request made on behalf of the petitioner.
Yes, Lordship.
Matter stands deferred to be listed after 3 hours. Yes.
Fair please, Lordship, I beg to mention for listing of the writ petition. The matter is related to non-payment of pensionary benefit. We will
When was it last listed? Let it come in
20th.
July. July. Let it be on 20 July.
Lordship, the matter is the name A.K. Das. Matter is
Good understood. Let it come in July, 20 July.
Lordship, the matter may be listed before any other bench.
That I can't do. You are making don't make a mention before this bench. Why are you making a mention and asking it to be listed before any other bench? Can't be done. I can only direct listing or off listing from this bench.
Lordship, this is the senior.
Whatever it may be, then let it be listed. Let it be listed. Thereafter, you renew your prayer, 20 July. Yes.
I have a prayer regarding item number 25. My lord, the conducting counsel from medical emergency, Mr. B. Patam. Kindly adjourn the matter.
22 and the request made on behalf of the counsel to the petitioner stands deferred. Be listed after 4 weeks.
May I please, Lordship? Lordship, can we listed the matter on Monday, Lordship?
Why?
Lordship, it was last listed on 31st of March. Since then, it has not been listed, Lordship.
What is the matter?
Matter regarding promotion and area of 1% increment was there. Lordship asked the department to obtain instruction.
Let it be on 10. Yes.
May I please? Lord, the petitioners before your lordship, they applied for the post of Gauhati. Pursuant to annexure 2 document, that is the authorization issued by the district commissioner. The interview was held on 13/12/2022. They appeared for the interview. Based on that, Lord, the result has not been declared.
So what is the urgency that you mentioned that urgent orders are required?
Because, my lord, now the petitioners have come to know that the respondents are likely to come with a fresh advertisement without declaring.
How have you come to know?
Because we are pursuing the matter before the official.
If they let the advertisement come, then you challenge it.
But in that, my lord, since we are pursuing the matter and we also submitted some representation, my lord,
You may have submitted,
Fine.
but where is the urgency? You made a mention before the court. That is why the matter was listed today. that there is urgency in the matter, orders that will have to be passed. What is the urgency? What urgency are you expressing?
That is that we not we. That's the we
All
not
right, heard
decided-
Mr. Counsel for Party, Mr. A. Chakraborty appears for
Respondent for lordship. 2 and 3 lordship.
2 and 3. Who is appearing for 1? Mr. S. Dotto. Since the respondents are represented, notices the way the extra copy is furnished within a period of 1 week. List after returnable date, 4 weeks.
Obliged.
Obliged.
Your Lordship, Madam, before my learned senior start, my lord, on last occasion, this honorable court has directed on an additional AG P Nayak to get some instructions or elementary records, my lord. Lordship, today morning he informed that he is praying for 2 days more time, Lordship, yet to receive the relevant portion, my lord. Lordship, kindly next week, my lord. So, Sukhendu Bhattacharya is not applicable in this matter, my lord. Paragraph 79, subpara 7.
Your work charge or master role?
Master role.
But I think the issue here is that according to the respondents, the order of appointment was recalled or cancelled.
It was never recalled.
So that is their stand. And it is to that extent the records are required to be
Right.
produced.
That record, they failed to produce my lord and my lord.
When does he want?
Next week, my lord, on 10th, as per my lord convenience, otherwise next week.
11.
11th,
Last chance, my lord.
Yes,
11th of June, my lord,
the 11th of June,
Sure.
Thursday.
deeply obliged.
The matter was fixed today, and the request made by Mr. P. Nayak additional for production of necessary reports, connection with the petition. That some further time is necessary, and as prayed for, and as prayed that the matter be listed next week. Mr. Soitia, counsel for the petition, submits that further time should be granted on the next date. Matter of time should be made to dispose of the petition accordingly. This matter on 11th
Lordship,
of June.
I'm deeply obliged. Lordship.
That we say that attempt will be made to dispose of the petition. That we-
So deeply obliged.
along with the contempt case,
Deeply obliged.
1 and 2 together.
Yes, was dismissed by the Supreme Court on 19/5. So, my lord, by order dated 18/12/25, my lord,
Yes, what
May I
is
please,
this?
Lordship, Mercedes alleging for number 1. And here, since the review petition is dismissed,
He was
my
dismissed more than 6 months back.
so is dismissed, Lordship is dismissed on 19/5.
No, it says stood SLP file with.
SLP was
Okay,
dismissed,
and
there are
Alright.
some review petition was filed, and that was dismissed on 19/5.
Then
In
Lordship,
fact,
Lordship, here I'm directed to seek time for 3 weeks to extend.
3 weeks, why 3 weeks is necessary? Because this is an order of which year? 21, 22?
yes,
Then
22, my lord.
22, why so much of time is necessary for compliance?
In fact, your lordship, 18/12/25 order may kindly look into, passed by the Supreme Court. 18/12/25. court directed them to submit compliance.
So we get it next week, you give us your status.
Lordship, may kindly take up after the application.
No, next week. There are, these orders will have to be complied with. This is sitting on the order, one after the other, one occasion after another occasion. Who is the person required to comply with this order?
One and both, the secretary and
Lordship,
Which department is this?
social
Social Welfare
welfare.
Department.
Social welfare. Why are they taking so much of time to comply with this order?
Lordship, as a is going on and after review petition.
So it is dismissed, so now they'll have to, they can ask, they are already in contempt. You explain to the clients that they are already in contempt. Direction of the coordinate bench is to implement the direction within 60 days from the date of the order. One pretext, the other, the order has now been 45. So we'll give you another 30 days to comply with this order, failing which we will initiate proceedings. I heard Mr. S. Kotoki, learned counsel for the petitioner, Mr. I forget
Arsana
who.
on Gauhati.
Mr. So on behalf of Mr. D. Nak, it is submitted at the bar that the SLP preferred by respondents against the order passed by division bench of this court upholding the order of the coordinate bench stood dismissed on 15/10/25. Thereafter, a review petition was filed, which also came to be dismissed on 19/5. So, the learned counsel appearing to the respondent submits that you require 3 weeks time to take the instructions. From the order passed by the coordinate bench, it is seen that the direction was required to be complied within 60 days with effect from the date the judgment was. Which is 2006/2022. Therefore, this court is of the view that in view of the submissions made by the counsel for the petitioner, the matter be deferred to be listed immediately after the reopening on 15th of July, by which date the steps taken by the respondents for compliance with the directions of the order be placed before the court, failing which consequential orders will be passed by the court.
I know the Lordship.
There are two matters here, 3 and 4. Two matters,
Lordship.
3 and 4. Yes.
No, Lordship, my lord, similar matter is pending before the division bench on 11/6/26 regarding non-regularized casual worker or works as employees. There are so many judgments of the Honorable Apex Court that they are entitled because state cannot take the benefit of their own mistake.
You are seeking a review of which order now?
Review of that order, Lordship, may kindly see page 18.
(17/7).
Yes,
There is some appeal pending.
appeal pending.
Yes, respondents?
Lordship, I'm appearing on behalf of P. Nayak, property instruction.
He was also present on that day.
What is the writ appeal number?
Data bill number 163, 2026.
It is submitted to the buyer that similar issues are pending before appellate court school of this high court. Data bill number 163 of 2026. Counsel for the petitioner therefore submits the matter be deferred to be listed after reopening applications. Accordingly, this released this matter in the first week of August. Parties are given liberty to apprise the court on the next date regarding any such orders that may be passed by the appellate bench.
Any day after 11/6, because
First week of
my
August,
husband already died. Now I am also some addresses.
third of August.
Right.
The dispute here.
My lord, here this matter, my lord, they appointed arbitrator one after another, and 17 years have passed. And the Honorable Court, Supreme Court has dealt such type of cases where the Honorable Supreme Court has appointed independent arbitrator. I have filed the retention of my time. Petitioner, my lord, in
We
home
hear it on 23rd of June.
my lord,
23rd of June. 3rd of June.
not my lord, 24, I have some other case outside.
You make yourself convenient. We'll have to close this matter.
Yes, yes, my lord, pending last.
Eighteenth of June.
Yes, my lord, 18 some.
You give us your calendar, we'll fix dates as per your availability.
No, on my lord, 23rd, my lord.
That is what
19.
we said, 23rd.
19,
23rd.
my lord, 19. 19.
19 is not possible. Don't pick a miscellaneous day. You want the matter to be heard, you pick up a hearing day.
Yes, yes.
Release
11th
this
my
matter
lord,
after vacation.
11th, my
After vacation, instead on a date to be fixed by the registrar.
both the cases.
Lordship, in this matter, I have received instruction, Lordship, but this is incomplete. And Lordship, actually the chairman, he is also out of station. So kindly allow me 2 weeks' time, Lordship.
Yes,
Out of station.
as agreed to by both parties, matter be deferred to be listed after 3 weeks
Deeply obliged, Lordship.
on a date to be fixed by the registrar.
Please, Lord. Regarding non-payment of salary since 2019.
Yes.
I have received verbal instruction that there is some problem in the appointment of.
So what verbal instructions? Why this from 25, these matters are languishing? Who is supposed to give you instructions here?
Basically, it come from the executive engineer, Your Lord.
Then
On Wednesday, Your Lordship, I will try to get something done.
they better be called the executive engineer here along with all records. Let him explain what steps he wants to take.
One chance may be given here before date, Your Lord. Second. I understand the message. Yes, Your Lord.
You're still working.
Yes, Your Lordship.
Where is your appointment order?
From the page, start from page 14.
14.
14, annexure 1. Start from there and from time to time it was renewed. So different orders. And my salary was also included accordingly. Like I have written letter to them, representation also submitted regarding non-payment. But there has been correspondence with the officers, in between the officers, but nothing has been done.
Document to show that.
That is for the department to tell us whether they're working or not working. What is the process in how they have been into this? No instructions are coming. Released on 10th on the request made by Ms. Ardeka, Standing Counsel for
Water.
Water Resources.
Obliged.
Mr. I. Ahmed for the petition.
Yeah.
Then on 15th, Mr. KK Medi appears for respondent number 6. 15.
The connected matters in item number 14, Lordship, we have filed an affidavit that is not on record. Today itself we have filed.
Why have you filed it today? When was the matters fixed? 5, 1 month back. Why have you filed it today?
I have instructed Lordship. File it today itself.
This is a ploy to get the matters deferred. We can't do that. You know the matter is fixed today.
Sure.
How do you file a matter? How do you file the pleading today morning or yesterday? When you know the matter is fixed today. If it is a matter which has come out of turn, I can understand. In the presence of counsel, the dates were fixed. What is the point in fixing a date if it has to be adjourned again and again on this pretext or the other?
Any day in this week itself.
No, what any day? What have you stated in your affidavit?
Order number 3 has filed the affidavit, Lordship. The nodal officer.
Have you received copies?
That's it means.
This is being unfair to the court. Matter is fixed, you file copies and compel the court and the council to defer the matter. This is unfair. Unfair practice, I'm sorry to say. It is submitted by the council appearing for
On the state respondent.
state respondents. That an affidavit has been filed today
Lordship.
in the morning with copies being served on the council for the petitioners. Which matter? In
item
in
number 14,
WPC number
WPC number 6065 of 25.
6065 of 25.
Lordship.
Stop. Counsel for the petitioner has also acknowledged the service of copies during the course of the. Now, what about the other matters? Are you relying on only one affidavit?
Lordship, yes.
They are relying only one affidavit.
Yes. One affidavit that suffices.
So, my lord,
It is the submission of the counsel for the state
Lordship, copies are being made
that
ready.
the affidavit filed in WPC 6065 will reflect the stand of the government in respect of all the other writ petitions. Under such circumstances, the respondents are directed to serve sufficient copies on the counsel for all the other writ petitioners within 3 working days. It is come to the notice of the court that the matter was last listed on 5/5/26 and was accordingly fixed today, namely 4/6/26, in the presence of all counsel. Therefore, the court does not appreciate the conduct of the state in filing the affidavit today in the course of the day when the matter was known to be fixed today, the state council. Such practice is deprecated and is expected not to be repeated in future. The effect of resorting to such a practice is that the matter had to get deferred. In spite of the court fixing this matter today by the earlier order dated 5/5/26 in the presence of both counsel for the petitioner as well as for the state. Be that as it may, considering the fact that the affidavit filed today will also be the stand reflected, the stand relied upon by the respondents in respect of all the other writ petitioners. Copies of the same be served as directed. The petitioners are also given liberty to file their response. Release this matter in the month of July on a date to be fixed by the registry.
Lordship, if it may kindly.
No, it will be fixed by the registry. It will be fixed by the registry You-
Pending matters.
in July. It will be fixed by the registry.
May it be sometime earlier. Good because of my lord. May it be, my lord.
Have you received copies of the affidavit? Then
My response before there.
let it be after petition. Yes.
Obliged.
My lord, one IA, I filed one IL for equipment.
They will take it up on the next date. Everything on the next date. Yes.
Lordship, pursuant the earlier two affidavits, the respondent authorities have not filed an affidavit in opposition till date.
Heard counsel for the petitioner. The petitioner is challenging the dismissal order of the writ petitioner. Notice in the matter was issued on 4/2/2026. So thereafter, the matter was listed on 5/5, and when opportunity was granted to file a response by the respondents, stopped. Considering the fact that this is the matter challenging the dismissal order, issue call for the records matter be listed in the month of August in the hearing list. So like, passed over.
Regarding one of that, election and appointment of the Gauhati.
Where is the petitioner? Mr. J. Henry, Mr. Goswami for state, Mr. S. Islam for private respondent. Stayed in the month of July.
Submission is there is no evidence at all, expertise.
It's for the respondents.
The Bora was there last. They undertook to commit the not a promotional. For the timing in the meantime, I'm trying to.
Bora. DP Bora. Health, Standing Council Health. Pleadings are complete.
Yes.
They submitted that the pleadings are complete.
We have a little urgency, although there is a team order operating.
The matter be listed for hearing. Month of August.
August would be immediately on.
Just around the corner, August. No. We are already in June.
Immediately after reopening, any date convenient to your lord.
Let
And
it
not,
be-
not for let it be for admission only.
No, it's for hearing. Pleadings are complete. Why should it be for admission? Have to be heard.
There is a issue of maintainability also.
Is there?
Yes.
We've raised this question
Yes.
by the affidavit.
Yes.
Meetings are complete. Mr. Rai Chaudhary, Learned Senior Counsel, appearing for the ONGC,
When this?
submits that the question of maintainability is raised by the petitioner. Therefore, the matter be listed for hearing on the point of maintainability for admissions immediately after. The date to be fixed by the registry in the month of July.
Not inconvenient. Can a date be fixed that way? I can schedule my Arunachal trip. 16th, 14th or 16th of July. Or maybe even 23rd.
23rd. 23rd.
Right.
Lordship, kindly pass on the letter for my senior, for time being, my senior is present another courtroom.
Timing. Timing.
Yes.
The petitioner was retired from service on 28 to 22 from the post of superintendent in Director Assam. And since then, she is not getting her regular pension because of the fact that her pay, it is a revised pay as per the provisions made in the Commission Code 1989. Her pay is to be effective from 1st of January 1990. And according to the government, on that day, her pay is to be fixed at rupees 1255. But the G have objected that her pay needs to be fixed on 1225. Respect, my lord, in our the government fixation like that. Page 26, my lord. That from which the revised scale is applicable, 17,389. And this scale is 500 to 875. Emoluments, the basic pay, 500. Journalist allowance, 515. Special pay, 21. And interim relief, 80. According to the provisions made in the ROPs, my lord, the revised pay is to be fixed on the principle of basic pay plus day on the date of previous day of the affecting revised pay, and interim relief if any, special pay if any, and on the basic pay 20% of fixation benefit. On that count, the government has fixed her pay 500 basic pay, 515 DA, 21 special pay, 80 interim relief, and 100 at the rate of 20% on basic pay is 100. Altogether, the pay was to be 1216, but there is no slab. There is no slab. 1216. The next step is 1225. And 200 on as on joining that, on adding that, the hard pay on is to be 1225 as on 31st or as on 17,389, and there is her increment that on first day of the year, January. So after adding that 100, her pay is fixed for 255. This is the controversy with the government and also the AG minor. In this respect, in similar matter, identical matter, there are numbers of cohort cases of Honorable High Court minor.
Where are the orders?
You know,
Where are the judgments passed by the court?
page 19, I would like to read the 19. First,
No, you mentioned about some orders.
yes, my lord, copies of GLR 64654 at page 40 onwards. Page 40. Again, order dated 21st to 22, passed in resolution number 244, 2019, are annexed here and marked annex 6, page 37, 44, and page 36. I am going to read the GSR, GLR at page 40, my lord. Honorable Mr. Justice P.K. Sharma had for order 16/11/2012. Both the repetition raising the same grievances into fixation of pay as per ROP 1990 have been heard together and are being disposed of by this common judgment and order. So I may perhaps the order, the part of the order. Of the above, the best put 3 my last year. Review the above, the matter needs the consideration of the respondents. Consequently, with the observation made above and strictly in terms of the provisions of ROP rules 1990. Accordingly, both the petitions are disposed of, directing the respondents to the grievances of the petitioners for refixation of their pay so that same does not amount fixation at a stage which is lesser than the total emoluments which they used to receive under the revised bylaw. So accordingly, the government has already complied with this order. Is 39. Just for 53 note. Serial number 2, Srimati Minoti Mujumdar. Her pay was, basic pay was 500 prior to the division. And he was 512. And her pay was fixed at 1125. As on before the death of affecting the division pay. And ultimately her pay was fixed over 1255, paid from 1190. Like this petition, serial number my lord 9, Madhavi Boro. And also serial number 11, Ranjurani. All of their pay are fixed at 1255. Similar case there also. In instant case also,
Similar.
the basic pay of the petitioner is 500. The same scale of pay. Same month of the joining in service. Petitioner joined in 1739, and they also at the same year they also joined in service. So their pay was also 500, and this pay of the petitioner is also 500. But there was difference of 3 rupees because of scale. In that case, their DA was 512 and petitioner's DA is 550 by law as per the government calculation. So this is a covered case, not only that, and also regarding rule, page 9 my lord, 9 there is clearly have stated. Page 8, last paragraph from last paragraph, that it is stated that the pay of the petitioners has been fixed at this stage, which is lower than the total emoluments, which he used law for the division of pay rules 1990. Then it will be violation of
You are praying for a similar order.
similar order. All are similar order. 5-6 cases are there, covered cases. So it's a very simple thing, my lord.
Yes, Mr. Bora.
My lord, we have filed affidavit, my lord, We have already forwarded the pension papers of the petitioner to the AG, my lord. And in our, if your lordship perusses my affidavit page, it starts from page 67. There we have annexed one letter, initial letter at page 74. We have forwarded the pension papers of the petitioner to the AD, my lord. Then white annexer A at page 74, my lord. The pension paper of the petitioner has been returned back with certain observation, my lord. Then again, my lord, we have clarified it and forwarded white annexer B at page 76, 77, white letter dated 7/6/2023, then again on 31/8/2023, my lord. We have forwarded the pension papers. Then again 6/11/2023 also we have requested the AG to settle the pension in respect of the petition.
Then what is the AG? What were you doing? This was sent way back in 22, 23. What are you doing? Huh? What instructions? What is this annexure A?
Annexure A of the
Your
affidavit.
affidavit?
Yes, my lord. Because initially when we sent the papers, my lord, then it was sent back, my lord. 15, with certain observation, my lord.
My lord, that is a case of covered cases, my lord. Similar cases.
No, now it is being sent to the Accountant General's office.
Yes, my lord. But the government, the director has also replied. I am going to reply at page 28, my lord, my petition.
Page 28.
I say,
Yes.
from Joint Secretary to Government of Assam to Joint Secretary from Director of Health Services. Letter number Iman, subject return of pension case with respect to Srimati Kiran Soharia, retired superintendent. With reference to the subject and the letter received from the principal AGAE Assam, cited above, I have the honor to state that the principal AGAE Assam has returned the pension paper of Srimati Kiran Soharia, retired superintendent of Directorate with the objection as to the wrong fixture of pay and benefits extended under MACPS 5, number under reference. The principal AG has requested to return to resubmit the pension paper in compliance with the observation made in AG's letter, which has been requested to number clarify as to fixation of pay of rupees 1225 instead of 1255. 255 rupees, the amount of the revised scale, along with the photocopy of specific order, if any, and to clarify as to the MACPS was allowed take from 1/1/2017, whereas in terms of government notification FPC number 109/2010/20 dated 25/5, she was entitled for
You are appearing for Mr. Talukdar.
Master,
Where is he?
Master was my lord. That is fixation of the pay, my lord.
No, that's right.
The
We want to
other
know.
matters subsequently come.
We want to know what is the instructions from the Accountant General's office because the papers are with them.
So they have returned the paper.
So he says
Again-
it has been
again-
sent back.
Another order is that, another letter is that. Page 30, what is it pay?
Mr. Bora, is it sent back? Have you sent it back?
This instruction I have to obtain, my lord.
No, then we are closing the matter in terms of the orders which are passed here. We'll dispose of the matter in terms of the earlier judgments. All right? I'll dispose.
Obliged, my lord.
We'll pass orders. Mr. Decker will pass orders.
Obliged, my lord.
What is the record?
Yes, my lord, I have received the record, my lord. I have arranged the record, the manner.
For the particular charges.
Record shows that, my lord,
That
is
is con-
in the given address of the petitioner, my lord, it has been sent many times, my lord. But he refused, the article of charge has been received by him, my lord, initial record revealed, my lord. But subsequently, all the communication in the given address of the petitioner was given in the Tezpur Medical College and Hospital Authority, my lord. Either he has refused or he has not received, my lord, it returned back. Subsequently, finding no other alternative, my lord, a paper publication was made, my lord. That is also there in the record. After paper publication, my lord, it has been proceeded. And during his period of suspension, my lord, when he was under suspension, although it was his duty to attend the college authority, but he never attended, my lord. Tactfully avoided to receive all the communications, my lord. My lord, the paper publication was made in the widely circulated paper, my lord, the Assam Tribune, my lord.
The envelopes show that it was, at least one envelope is there where there is an endorsement that it was refused.
Your lordship will kindly see the statements. The light of the judgment passed by this court, I'd like to take your lordship to paragraph 10 of the judgment.
What happened to the appeal?
Appeal was also dismissed. We have stated that inquiry for report was not given, somebody has to prove it. They have sent the copies to us, then they have to prove it that it was sent to us with all the things. And then may I take your lordship to paragraph 10?
Of?
The judgment I have given to your lordship.
Is there no note sheet or anything like that that is maintained for the disciplinary proceedings?
My lord, all the proceedings have been mentioned there, my lord.
Where?
My lord, date-wise, my lord, all the proceeding from the first, after.
Date-wise means somebody has to maintain a file.
Yes, my lord.
The inquiry officer is required to maintain the file.
Yes, my lord.
Where is that file?
This is the file, my
How
lord.
can it be a file without any signature, without any endorsement? There is no, in the sequence of dates that you have given, there is no endorsement. Who has prepared it? It has to be a file, like we maintain a file on which
Yes,
date
madam.
what order was passed, for what purpose the matter was listed. So this is a proceeding
That proceeding is there, my lord.
where
In every subsequent event, my lord, all the events have been, is there, my lord.
all the events you have recorded, but when you
Date-wise,
were,
all the proceedings are there in the records, my lord.
where are the records? That is what we want to see. We want to see
Yes, my lord.
how the records were maintained.
Yes, my lord, I can.
the judgment which is one of the paragraphs of the judgment.
Yes.
In the paragraph 10, that Satyendra Singh case.
You have given some judgments.
Yes, one judgment I have given. And along with the note, remember I have given a note,
No. Yes.
the flag mark is there.
Ah, yes, yes.
I'll just read paragraph 10. Therefore, here rule 9, rule 7 of the rule 1999, which prescribes procedure for imposing major penalty, would be applicable in the inquiry to be conducted against the appellant to bring home the charges imputed to him. Paragraph 13, the court Catena of judgment has held that the recording of evidence in disciplinary proceedings proposing charges of a major punishment is mandatory. Reference is given to these cases. And paragraph 14, in the case of Rup Singh Negi, this court held that mere production of document is not enough. Contents of the documents, a documentary evidence have to be proved by examining witnesses. Relevant aspect thereof is followed. Indisputably, a departmental proceeding is a quasi-judicial proceeding. The inquiry officer performs a quasi-judicial function. The charges leveled against the delinquent officer must be found to have been proved. The inquiry officer has a duty to arrive at a finding upon taking into consideration the materials brought on record by the parties. The purported evidence collected during the investigation by the investigating officer against all the accused by itself could not be treated to be evidence in the disciplinary proceeding. No witness was examined to prove the said document. The management witnesses merely tendered the document and did not prove the document, the contents thereof. Here, not even the document was proved. Reliance Inter India was placed by the inquiry officer on FIR which could not have been treated in the evidence. Now, paragraph 15. Same view was reiterated in so and so, wherein this court held that even in an ex parte inquiry, it is the duty of the inquiry officer to examine the evidence presented by the department to find out whether the unrebutted evidence is sufficient to hold that the charges are proved. The relevant observations are follows. An inquiry officer acting in a quasi-judicial authority is in the position of an independent adjudicator. He is not supposed to be a representative of the department's disciplinary authority government. His function is to examine the evidence presented by the department, even in the absence of the delinquent official, to see as to whether the unrebutted evidence is sufficient to hold that the charges are proved. In the present case, the aforesaid procedure has not been observed. Since no oral evidence has been examined, the documents have not been proved, and they could not have been taken into consideration to conclude that the charges have been proved against the respondents. Paragraph 16, my lord. In the case of so and so, this court held that evidence recorded in a preliminary inquiry cannot be used for a regular inquiry, as the delinquent is not associated with it. The opportunities to cross-examine persons examined in preliminary inquiry is not given. Relevant paragraphs have been quoted. I skip this and not come to paragraph 17. Thus, even in an ex parte inquiry, it is sine qua non to record that the evidence of the witnesses for proving the charges, having tested the fact of the case at hand on the touchstone of the rules of 1999 and the law as expounded by this court in Rup Singh case, which I have taken the lordship before, we are of the firm view that the inquiry proceedings conducted against the appellant pertaining to the charges punishable with major penalty were totally vitiated and non-honest in the eyes of law, since no oral evidence whatsoever was recorded by the department in support of the charges. As a consequence thereof, the High Court fell into a grave error of law while interfering with the well-reasoned judgment rendered by the court. So, your lordship will kindly see that the charges which have been framed from the record which I have found, that the charges which have been framed, that is on 15/9/26. 15/9/26, engaged in the affairs of publications of newspapers, engaged in a mobile theatre group. The charges 15/9/16.
Page number?
From the record, I have taken note of. I was allowed to see the report.
No, you charge the
This
Show cause is not
because
here.
Show cause has not given to me. The inquiry report, I got it in another case.
Where is the inquiry report?
Inquiry report is
'64. Charges are not mentioned here.
when came, I know. I was absent and all this was not in the chart. And your lordship will kindly see the statements of 3%, what they have proved. 3%, whether they 3 witnesses are there, I have seen nothing in there. With the allegation is that yes, I have given everything has to be proved by documents, even in regard to publication of the paper news. This is not said nothing about the charge. And whether the inquiry officer will even discuss statement of the witness. Also, we can see the record whether it is based on MLB. Paragraph 25, 26, 27, 20. Same. Statement of only 3% are there. Something about absence. Statement of witnesses your lordship will find absence from duties. It was not even a charge. Record your lordship looked into this article of charges. Some documents are there, as well as 10 documents. Nothing has been true.
Got it.
The green tag mark, all are the proceeding, my lord. The purple flag mark, that is the paper publication, my lord.
No, in any department, when you maintain a particular file, there are note sheets available.
I understand that note sheet, my lord.
So how the inquiry officer is conducting the inquiry without maintaining such a file? There has to be notes given that on which date it was sent, what happened.
But all the proceedings, my lord, that I have flag mark with the green color flag, that says that, my lord, all the proceedings have been communicated to
No,
the
let us say, for instance, you have sent a notice. The notice has come back. From where do you say it has come back?
Yes, my lord, I understand. That notice which has come back, my lord, that is also there in the record.
Right, but
I understand, my lord.
who
That
says
note
it has come
sheet- Yes,
back?
my lord. That note
Where is
sheet,
the
my
where
lord,
is
has
the
been-
where is the view of the department or the endorsement of the department that it was sent on so and so date, it has not been served?
Actually, my lord, what happens, my lord, the problem, the
Who was the inquiry officer?
inquiry officer who was there at that point of time, my lord, now he has been transferred to some other place. So the concerned officer of the Tezpur Medical College, somehow collected these records, my lord. And that note sheet also they are looking for it, my lord, but probably.
You know, what kind of an inquiry is being conducted like this? He's transferred, doesn't mean that he's going to take away the records with him.
Is that, my lord, because once a speaking order was directed to be passed, my lord, for passing that speaking order, my lord, the records were taken, my lord. Then probably it has been misplaced. That is the actual reason, my lord, that has been told.
Speaking order was?
One speaking order was directed to be passed in respect of the subsistence allowance of the petitioner, my lord. And that has been passed also, my lord. So in connection with that, my lord, some of the records were taken, my lord.
By whom?
By the speaking order issuing authority, that is the principal cum chief superintendent of the college, my lord. Probably that time, my lord, the record got misplaced, my lord.
But if the record got misplaced, how did you get hold of these?
These records somehow they have collected, my lord. That is, I have been told, my lord.
That is a very
Also probably
very unreliable submission you are making. Collected from where?
from the office of the principal.
How will it be there? That must be retained in a particular set of files.
Yes, my lord. That's why I am saying that for the purpose of issuing the
For
speaking order.
instance, I'll tell you that this is an order, let us say the daily order sheet.
Yes, my lord.
Daily order sheet is there, it is not shown that it is marked to some other officers. Now, if the file is not available, then this daily order sheet would not have been available.
The note sheet I will try to obtain if somehow it can be, because my lord, actual problem is that when from the file, my lord, some documents were taken for the purpose of issuing the speaking order. That, my lord, at that point of time, the order.
The statements of but I understand now that they say that they have sent a notice to us. That notice has to be approved by way of a witness. This is what the Supreme Court said. This is what I understand. Subject to.
Sorry.
And that if they say that the notice has been sent to us, then the witness must come before the inquiry officer and say they have not come and this is the registered post stamp and all. There must be a statement before the officer.
All right, but the public notice is there.
But it is also not there, not been proved.
No, what is there to be proved? I mean, you are not before a criminal court. This is a quasi-judicial authority.
What I am saying,
where the principle has to be followed, but it is not a case that the publication was not available.
Expertise, inquiry, all the allegation has to be proved.
Where does one find the charges? What are the charges?
Charges in the very first of the record. That is the article of charges.
I think it is dated 15/9/16.
That has been received by the,
As many as so many documents are there.
that has been received, my lord. That AD card has come back, my lord, with the enrollment.
Regarding these charges, what evidence has been led by the department?
My lord, in the inquiry report, it has been discussed, my lord, in detail, because there are some documents which have been exhibited before the last portion of the records, my lord, the inquiry report is there. So there, every search, regarding every charges, it has been discussed, my lord, on what basis the charges has been proved, my lord. Because the documentary evidences are there, my lord.
Where are the depositions? Is it available?
Yes, depositions are there in the record itself, my lord, depositions are there.
Do one thing, Mr. Bora.
Yes, sir.
Find out the charges, frame, and the evidence before the inquiry officer vis-a-vis the oral evidence, documentary, whatever is there. To identify that, say, charge number 1,
Yes, madam. I
evidence
understand.
at page number so and so, so and so.
Along with the exhibit.
Along with only the exhibits
Yes, madam.
or the statement of the witnesses.
Yes, madam.
Then you'll be able to find out.
Yes, madam.
It is slightly not in a sequence.
Yes, madam.
Let him do the exercise. We'll just follow up again on Tuesday.
I have gone through the statement of the 3 witnesses. Nothing has been proved.
We will follow up again on Tuesday.
My lord, can it be, because my lord, that note sheet also I will try to obtain, my lord, in time.
May not that you
And-
try to do it if it is available. Otherwise, we have heard this matter.
Yes,
We
madam.
would like to close it.
Can it be on Thursday, my lord? Thursday.
Thursday. 11. 11. 11. Matter has been heard at some length for further hearing on 11.
Or can it be on 16, my lord?
No, don't. delay.
Actually, my only submission is that, my lord, all the exhibits have not been provided. I have
You
sought for
get
them, my lord.
whatever is there, we'll examine
So
it.
it may
See,
take
if
time.
required, we'll give you time, but let us not delay the matter.
Yes, I understand. That's why
We can finish off the matter today, but we are giving you an opportunity to correlate.
First, they have produced the photocopy of the.
my lord, otherwise his conduct is also not, because
Therefore-
after his reinstatement also he did not join.
No, that is a different issue.
Yes, my
You
lord.
have enabled certain charges against him.
Yes, my lord.
Now, this is an ex parte. So you will have to satisfy what are the evidences
Right.
on the basis of which the inquiry officer returned a
That's why, my
finding the
lord,
charges.
the exhibits will be important, my lord.
Exhibits, evidence, whatever is there.
Yes.
So you
Exhibits
correlate
are
and
not, exhibits are not there in the record, my lord.
so get it.
Yes, my lord. That's why, my lord,
For further hearing.
on 16th, my lord, can it be? In the meantime, I will try to get it. I understand. That way, my lord, I will try to prepare the records, my lord, against it.
16th?
Right.
All right, 16th.
Come prepared, my lord.
As requested by Mr. D.P. Bora.
Yes, my lord.
An attempt will be made to dispose of the matter on the next date of listing. Mr. Bora is permitted to mark up relevant exhibits
For further
from
hearing.
the evidence of the witnesses from the reports and place it before.
Public, my lord.
The lordship has heard the matter.
Yes, pardon. Records produced before the court are returned back to Mr. Bora.
Another, sir, Ankit is today, APS today. That's the beginning. 22 or 23rd.
It will be in July.
Rusty, then I will be out of station from 2nd July to 13th July. Then after
It has to be after 13th July only.
Oh.
This submission is made on behalf of the station. Matter stands before. Party stone. 23rd of July.
on date
23rd.
20.
Happy, my lord. I'm appearing in item number 28, my lord. So our prayer in this matter is, my lord, we are praying for promotion to the post of Panchayat Secretary, my lord, from the post of tax collector come Rod Mahadan, my lord. My lord, as per provision of the Assam Panchayat administrative rule, my lord. The hierarchy of posts in Gauh Panchayats are provided, my lord.
Yes.
As per Rule 2, Sub-Rule C, my lord. For Gauh Panchayat, grade 3 staffs are given as secretary, and the next post is tax collector cum road moharar, my lord, and grade 4 staff is peon cum chowkidar, my lord. Now, regarding the appointment of Panchayat secretary, my lord, the provision is silent, my lord. As per Assam Panchayat Act of 1994, Section 30, my lord, staff of Gauh Panchayat is provided, my lord. In that, the provision reads as follows, my lord. There shall be a secretary and other staff as may be prescribed by government in every Gauh Panchayat who shall be appointed as provided in Section 140, subsection 1, and or decreed by government from time to time, my lord. So the provision is clear that there shall be a secretary that is separated by a comma, my lord. So there are two clauses in this provision, my lord. The other staffs in Gauh Panchayats are, my lord, tax collector, cum road moharar, and peon cum chowkidar, my lord. So to my understanding after reading this provision is, my lord, that the post of Gauh Panchayat secretary is a promotional post, not a direct recruitment post, my lord. So in this writ
Under
petition,
what rules?
rule, my lord, this rule 4
Of
of the Assam Panchayat Administrative Rules 2002, my lord.
Panchayat rules?
Yes, my lord, the Assam Panchayat Administrative Rules 2002.
Panchayat rules.
The page number 223, my lord.
Yes.
Rule number 4, the last paragraph, my lord. May I read, my lord? Provided further that such employees of different grades in Jilla Parishad or Anchalik Panchayat or Gauh Panchayat within the jurisdiction of a Jilla Parishad shall form a unit of district cadre of Panchayat employees, and their promotion from lower rank to higher rank shall be considered inter alia according to the inter-se seniority of such employees within the district, my lord. So here, my lord, in Gauh Panchayat secretary, the hierarchy, there are three categories of employees, my lord. The lowest one is peon cum chowkidar, my lord. They are education qualification is required as only class 10 pass, my lord. But for the other two posts, that is tax collector cum road moharar and the Gauh Panchayat secretary, the education qualification requirements are same, my lord. That is graduate with diploma in computer for 6 months, my lord.
You are now currently engaged as what?
Against direct recruitment to the post of Panchayat secretary, my lord.
You are working as Panchayat secretary.
We are working as tax collector cum road moharar, my lord.
Now you are claiming promotion to Panchayat secretary.
Panchayat secretary, my lord.
Under
And-
what rules? Is there a provision? There is no provision.
In fact, my lord, after the amendment of one, the secretary post is the only direct.
Then?
Section 140, subsection 1 of the Act.
140.
Yes.
One forty of check Panchayat Act,
Assam Panchayat Act 1994.
94.
Page number 141, my lord.
Amendment of 2023. my lord.
Grade 3, grade 4. Zilla Parishad.
Reference I have already quoted in my affidavit also. All the.
The same thing. What are grade 3 and grade 4 posts?
Those are in, my lord, section 30, my lord. And sorry, my lord.
My lord, it's a rule 2, my lord. Yeah, some Panchayat administrative rules of 2002.
For Gaon Panchayat, my lord, grade 3 are secretary and tax collector come road moharar, and grade 4 peon come chowkidar.
Where is the provision to fill up these posts?
My lord, provision is there, my lord. After the, my lord, rule 2, sub rule 3. May I read, my lord? Accept the post of head assistant, upper division assistant, accountant, which are promotional posts and are required to be filled up from out of the existing provincialized employees, both regular and ex-cadre. The posts which could not be filled up from out of the provincialized ones shall be filled up by the redeploying excess staff of this department and other departments having requisite qualification. In this case, that will not applicable, my lord. If posts still remain vacant, the same shall be recruited in the manner provided under section 140 subrule 1 subsection 1 of the Assam Panchayat Act 1994. The state government shall exercise such powers of redeployment transfer of posts which incumbents to districts outside the original district cadre. This rule is saying, my lord, this will be, my lord, section 141, and section 141 is saying only direct recruitment. And in fact, sub rule 5 may be seen, my lord, of the same rule. The post of Gaon Panchayat secretaries, to the extent of sanction strength, the provision under subsection 1 of section 30 of the Assam Panchayat Act 1994 shall be applicable. And section 30 is saying, my lord, 140 subsection 1. Direct recruitment on.
Yes. So direct recruitment.
My lord, may I kindly turn to section 30, my lord,
Yes.
of the Act. There shall be a secretary, there is a comma, my lord, and other staff as may be prescribed by government in every Gaon Panchayat who shall be appointed as provided in section
Appointed.
140.
Appointed.
Yes, my lord.
Yes.
So only the other staffs are to be appointed
From
as per
which,
section
from
140.
which rule do you say the secretary is the promotional
My lord,
post?
because there are two independent clauses, my lord, to my understanding. I may be wrong, my lord. Because it is said that there shall be a secretary and comma, and other staff as being prescribed by government in every Gaon Panchayat who shall be appointed as
Now, from where does the secretary come from?
my lord, in the Gaon Panchayat, there must be a secretary.
So from
according-
where will the secretary come?
So, my lord, the provision which is provided at Rule 4, my lord. Lordship may come to Rule 4 of the Assam Panchayat Administrative Rules of 2002. The last paragraph, my lord. May I read, my lord? Provided further that such employees of different grades in Jila Parishad or Anchalik Panchayat or Gaon Panchayat within the jurisdiction of a Jila Parishad shall form a unit of district cadre of Panchayat employees, and their promotion from lower rank to higher rank shall be considered inter alia according to inter-se seniority of such employees within the district. So, the different cadres in different category, my lord, their service has to be considered for promotion, my lord. Now, here in
Where is the cadre provided? Cadre?
my lord, the cadre is at
Rule
Rule 2, my lord. Rule 2C. In grade 3 staff, two posts are there, my lord. Post of secretary and the post of tax collector come road moharar, my lord. The requirement for their education qualifications are same, my lord. Graduate as well as computer degree diploma holder for 6 months. And grade 4 staff is peon cum chowkidar. So they are only class 10 pass. So there is no scope of promotion of this peon cum chowkidar to the post of tax collector cum road mahara. But the provision of rule 4 says there has to be seniority, inter-se seniority list.
This proviso to rule 4 that
Yes.
you're reading
Yes,
is only to define what is a district cadre.
Yes, madam.
So all the staff in the district
Yes, madam.
will be considered to be a district cadre.
Yes, madam.
Therefore, their promotion will be vis-a-vis the district in terms of their inter-se seniority
Yes, madam.
Right?
Within the district, madam.
within the district.
Yes,
But does it define the source of appointment to the post of secretary?
Because it is clearly stated that
You
Gaon
are
Panchayat-
treated to be a unit,
Yes,
district
madam.
unit.
Yes, madam.
Now, this is only in the event that promotion is required to be effective.
Yes.
Now, where is the rule where it says that how the post of secretary is to be filled up? Where
Because
is the section, the rule, notification?
Because there is no such service rule in this.
So if
regard
there is
also,
no
madam.
service rule, then it is up to the department to
Madam,
decide.
rule is there, madam. Sub rule 5. Sub rule 5.
As per rule 30.
Yes.
And
As per 30 is saying
says
141, madam. Section 30 is saying 141. 141 is saying direct recruitment. And in fact, in some similar, I have submitted one judgment.
But also in the same rule, sub rule,
In this case, my lord, they wanted from grade 4 to grade 3. And interpreting these clauses, my lord, this honorable court, my coordinate bench, had held, my lord, after amendment of section 141, there is no scope for promotion.
Prior to 141,
Prior to 141, that was silent, my lord. Before 2023,
what was the practice?
it was silent, my lord. In one, my lord, there is a one-time measure. Some my lord, employees were
Have you
promoted.
gone through the judgment? Give me a copy. Why don't you share the judgment? Why is it that you trust it before the court, assuming the court to follow it? You must extend the courtesy of sharing the judgment.
My lord, actually, on the last day, they were wanted to submit some judgment, my lord. That is why they have time. I thought, my lord, they will.
No, if you place it here, you must also give it to the other side.
because, prior to this, my lord, this recruitment, earlier, the post of Panchayat secretary were filled through promotion from the post of tax collector, capital murder, my lord. Only this time, they are filling up the post through direct recruitment, my lord. Earlier, they were filling up through promotion.
Earlier means it's prior to amendment. Once the amendment has taken place.
Yes, my lord. This amendment has come to force in the year 2023, but we were appointed in the year 2019. 19, my lord.
As
Tax collector.
tax collector.
Yes.
How many years of service is required?
There is no such
Then-
rule, my lord.
Then is it a case that the vacancies were from 2000 prior to 2023? Vacancies are available.
Vacancies were available, my lord.
Since when?
Like, my lord, nature of the work
in
are
fact-
totally different.
In fact, my lord, this some of these tax collector Kamrad Maharaj, they were appointed as in charge of some of the Gaon Panchayat secretary.
Maybe in charge is a different issue.
Yes, my lord.
But what is the source under the rules, under the government OMs for appointment or for filling up the post of secretary? Is it by way of appointment, promotion, deputation, what?
That is silent, my lord.
That is silent, so the government will follow the act, will have to fill up the gap. If you are agreed by this, then you have to challenge the provisions.
And my lord, as per our instruction, there was some posts are there, my lord. Still some vacancies are there.
Vacancies may be there, you go and appear before the authority as and when the notifications are issued for filling up the post.
Lord, Lord, may I kindly direct the concerned authorities to consider our service for promotion, my lord.
No, we cannot direct, because the rules and act does not provide for it. You have not been able to satisfy the court that you have a claim for promotion.
2023 as tax morer come road collector. Tax collector come road mower. So they are holding the post of in charge in the 2-3 other panchayat also as a secretary. And my learned friend referred the rule to sub-rule 5
Yes.
regarding the post of Gaon Panchayat secretaries to the extent of sanction strength. The provision under subsection 1 of section 30 of Assam Panchayat Act shall be applicable. So this is regarding sanction strength. Now, my lordship may come to the proviso. Provided that the appointment, engagement of Gaon Panchayat secretaries against non-sanctioned posts. Non-sanctioned posts shall be made in the manner prescribed under subsection 1 of section 140. So, this is two categories of here. Section 30, subsection 1 of section 30 dealt with the sanctioned postman. So, section 30, my lord says, lordship comes to section 30, my lord.
Yes.
Staff of the Gaon Panchayat, there shall be a secretary and other staff, and other staff as may be prescribed by the government in every Gaon Panchayat, who shall be appointed as provided in section 140, subsection 1. My understanding, my lord, there may be by comma and my lord, separated in different categories. My lord. So far, the other staff, they are dealt with the.
No, you are reading from
Reading by the section 30. Ma'am.
section 30.
Yes. Ma'am.
Yes.
Section 30.
1.
1. There shall be a secretary, comma, and other staff as may be prescribed by government in every Gaon Panchayat, who shall be appointed as provided in section 141. So 141 as per rule.
All right, we even if we accept your submission that this 30 subsection 1 is applicable, read with 140 subsection 1 is applicable only for other stuff.
Other stuff.
Then where is the provision?
Other stuff and as per rule 2, sub rule 5 regarding the non-sanctioned stuff.
Rule 2.
Rule 2, sub rule 5, so far the proviso is concerned.
Sub rule 5.
Provided the appointment, engagement of Gaon Panchayat secretaries against non-sanctioned posts shall be made in the manner prescribed under subsection 1 of section 140. So far the non-sanctioned post, our post, the sanctioned post.
So how are sanctioned posts to be filled up?
Sanctioned post, that is silent. Earlier, practice was that road moharar and tax collectors were promoted to the next post. Next post is the secretary. And my learned friend read the sub rule 3 of the rule 2. Sub rule 3 here dealt with the head assistant, upper division assistant, accountant, which are not the post of Gaon Panchayat. In Gaon Panchayat, there is only 3 posts: secretaries, tax collector, and road moharar, and grade 4 staff. So rule 3 is not applicable to us. And so far,
This is the judgment on grade 4.
They are seeking promotion from grade 4 to grade 3.
This has no relevance here. Because this is on appointment of secretary.
I'm just relying the interpretation of 141.
I mean,
Maybe, but that is with regard to grade
Grade
4
4
to
to
grade
grade
3.
in
Here
this
is a-
case also, my lord.
There is a question of appointment to the post of secretary.
My lord. My lord, in my understanding, my lord, thus rule 4 is for, my lord, heading, my lord, the salary, TAD and other allowances of provincialized panchayat employees and panchayat employees. This rule 4 is not for promotion, my lord. And in the proviso also, my lord, it's saying that it should be, my lord, under sub rule section 140, my lord, subsection 1 and 140. And section 140 is very clear that, my lord,
See, say rule 4,
Madam.
rule 4 2.
yeah, my lord.
Also, read rule 4 2.
Rule 4 to the salary, TADA and other allowances of panchayat employees appointed, engaged in the manner as under subsection 1 of section
So it is
140.
appointed,
Yes,
it is not promoted.
yes, my lord.
Appointed, engaged in the manner under subsection 1 of section 140 of the Panchayat Act and 1994 shall be borne by the respective Jilla Parishad, Anchalik Panchayat and Gaon Panchayat concerned out of their own resources.
My lord, they are also admitting that before the amendment, there were some scope. Now, after the amendment, my lord, without challenging
What
that,
was the position prior to amendment?
prior to amendment, my lord, no regular promotion was done, my lord.
What was section 140? You're referring amendment to 140.
140.
So what was 140 before amendment?
Before amendment, my lord, direct recruitment was not there. The commissioner, my lord, he was the authorized person, my lord, for appointment. But now after the amendment, my lord, direct recruitment board is there, recruit grade 3 and grade 4 separately.
Amendment, my lord, it's quoted in the below. Substitution of the first paragraph of the subsection 1 of section 140 read as for Jilla Parishad, Anchalik Panchayat and Gaon Panchayat, grade 3 and grade 4 staff shall be appointed by the Chief Executive Officer of Jilla Parishad on the recommendation of the District Selection Committee of the Panchayat and Rural Development Department constituted by the government in the Panchayat and Rural Development.
Direct scope was not there, my lord. But after the amendment,
What is the function of the state level recruitment commission? State level recruitment commission. What is the function? Is it only available for direct?
my lord, this is the state level recruitment commission. Yes, my lord. The council is also there, my
Who
lord.
is the council?
Each of them.
Even prior to amendment, the position was it shall be appointed by the chief executive of the Zilla Parishad on the representation of the district selection committee.
Yes. For the first time, they have issued the advertisement for direct recruitment.
So prior to amendment, it was not promotion on the basis of your seniority.
But practice was that, my lord, the road mohara tax collector were promoted to the post of secretary because in Gaon Panchayat there is no other post, my lord, above the secretary. So, my lord, promotional avenue, my lord, Lordship knows, my lord, that our High Court also recently held, my lord. That earlier, my lord,
Then you challenge the provision. Then you have to challenge the provision. Then you have to challenge the provision.
my lord, earlier, my lord, one last occasion, Lordship, the direct submit order passed by this court in earlier case.
This.
What happened to these matters? These are all interim orders.
Next order, my lord, 31/5, 2017.
31/5.
Prior to amendment, my lord.
Yes, prior to amendment. tendency, they were promoted.
Possible to interpret unless the rule is challenged. How the interpretation can be made? Because the rules are
Rule,
challenged.
it is true, rule, specifically it is not stated that it's a direct recruitment.
Or a promotion.
Yes, or promotion. So, the government may consider it whether because promotional avenue is very necessary in a
Therefore, you have to file an application seeking challenging or interpretation of the section. If the government, according to the government, these are direct recruitment. You say that no, some percentage should be left for promotion.
in the provision, they have also nothing to say that it is a clearly it is the direct recruitment.
In the face of the law being expressly provided for, where is the scope for the court to direct the department to take a decision contrary to the law?
Consider the whether so far the regarding promotional avenue.
That requires interpretation. For that interpretation, you have to challenge the rule or the section. You're not calling us to interpret. I mean, there's no challenge made that this is how this rule or the section was wrongly interpreted. Or notwithstanding the interpretation, your accrued rights of promotion are not being taken into account. Nothing is there. On what basis should the court direct the respondent?
The rule is totally ambiguous.
Rule is not, if the rule is there, you challenge the rule. Rule has to be questioned.
And they are still following the 2002 rule. Actually, after 2023 amendment, they had to amend the rule also. And service rule, they have not yet.
Which rules?
2002 rules. After amendment, they have not amended the rules.
So how are the rules? How are the rules in conflict with the amendment? This 2002 rules.
Yes.
How is it in amendment? How is it in conflict? Because there is no rule where it says that the Gaon Panchayat secretary is to be filled up by promotion. It does not say so.
Only that sub rule 4 it is stated that to prepare inter-se seniority list, relation list.
That district wise.
But
District wise.
on that seniority list earlier promotions were granted.
Right. But now there is to be undertaken by the district state recruitment board commission. And they have issued an advertisement.
Yes, direct recruitment. Advertisement in the earlier by passing an interim order.
And what is the qualification for these candidates? Graduation.
Page 63, Page 63 is the advertisement.
No, what we want to know is what is the requirement of the job of a Gaon Panchayat secretary?
Normal graduation.
What are they supposed to do?
My lord, both the cadres are totally normally different, my lord, because Gaon Panchayat secretary are the ex officio member of the Gaon Panchayat. And the tax collectors, they normally have the works in the outside of the office. Normally.
They can only permit you to file a representation, that's all. For the government to decide if they want to decide. Challenge the rules, so therefore, setting aside the advertisement. You are asking for 60% of vacancies.
Earlier,
Okay.
my lord, one rule is there, my lord. Assam Panchayat and Rural Development Service. In that, my lord, there was a 50%, 50-50 man. 50% promotional post. The, in some block development officers for it is, my lord,
Where is that rule?
next, my lord.
No, but is it available in this compilation? Which
No,
rule?
no.
It was substituted by which rule?
This rule called, my lord, Assam Panchayat Rural Development Officers Service.
These are officers for officers only.
Officers service.
It is not applicable to you.
Not every-
Dismiss your petition. What else?
my lord, the liberty may be given to him, file a representation so that, and in the meantime, my lord, if the petitioners, my lord, want-
Third counsel for the parties, these writ petitions are filed by the petitioners who are serving as tax collectors. Nalbari.
my
No,
lord, they are,
different districts.
different.
Working under the different Gram Panchayats. Petitioners are aggrieved by the advertisement dated 30/10/2023 issued by the respondent number 5 calling for eligible persons for calling for applications from eligible persons for filling up for this election and for filling up the post of secretaries in the various Gram Panchayats. So, is projected on behalf of the petitioners are that they are rendering services as tax collectors and only tax collectors,
Tax collector and road mower.
road moharars under various Gram Panchayat for several years. He submitted that the practice which was followed earlier by the department was for promotion, for filling up the post of Gram Panchayat secretary by promotion. So this was carried out in terms of section 140 of the Assam Panchayat Act 1994 prior to its amendment. So the learned counsel for the petitioner submits that after amendment, the section is that the recruitment for grade 3 and grade 4 under Zilla Parishad, Ansolik Panchayat and Gaon Panchayat shall be conducted by the state level recruitment commission for class 3 and state level recruitment commission for class 4 constituted under the Assam Direct Recruitment Commission. Stop. It is submitted that this amendment does not put an embargo on the claims of the petitioners for being considered for promotion as which are in force, namely the Assam Panchayat within bracket administrative bracket close rules 2002. Proviso to rule 4 provides that employees of different grades in Zilla Parishad, Anchalik Panchayat, Gaon Panchayat within the district jurisdiction of Zilla Parishad shall form a unit of district cadre of the Panchayat employees and their promotion from lower rank to higher rank shall be considered inter alia according to the inter seniority of such employees within the district. Stop the inter seniorities to be prepared by the Chief Executive Officer of the respective Zilla Porikot of the Panchayat employees recruited under the provision of subsection 1 of section 140 of the Assam Panchayat Act of 1994. So, definitely say rules the council petitioner submits that prior to amendment of Rule 140, in bracket 1, the appointments, the post of Town Panchayat secretaries were filled up. Basis of recommendation were filled up by orders issued by the Chief Executive Officer of the Zilla Porikot on the recommendation of the District Selection Committee of Panchayat and Rural Development Department constituted by the government in the Panchayat and Rural Development Department. So, according to the Learned Council for the petition, this process was followed by recommending the names of the Gaon Panchayat of the candidates within the Gaon Panchayat on the basis of the interest seniority list. The Learned Council for the petitioner also referred to some Panchayat within bracket Administrative Rules 2002 to submit that under Rule 2 within bracket C, the staffing pattern for Gaon Panchayat is provided as under grade 3 staff. The staffing pattern for Gaon Panchayat comprises of grade 3 staff. Grade staffing pattern for Gaon Panchayat grade 3 staff comprising of secretary and tax collector come road moharar, and grade 4 staff comprising of peon come chowkidar. Referring to proviso to Rule 4.2 submitted that within the district for these staffing pattern and inter-se seniority is to be maintained, and the posts are required to be filled up in grade 3 and grade 4 on the basis of the inter-se seniority of the candidates working under the concerned town panchayat. So, submitted that prior to the amendment of the section, so secretary town panchayat will filled up by the promotion on the basis of inter-se seniority prepared. Said town panchayat. So, also submitted that although the section 140 bracket 1 has undergone change, corresponding change or amendment has been brought of 2000. So, they submitted that the petitioners having rendered services in their post since the year 2019. 19 and 2023. Onwards, their claims for consideration for promotion stand negated in view of the issued by the wrong interpretation of the section of 140 overlooking their claims for promotion. The council found council for the hearing for the assembly that the for the interests of the employees working in the Gaon Panchayat, 60% of the vacancies ought to be reserved for promotion. And that not having been done, the present notification is filed. Praying for it. Yes. The department is represented by Mr. S. Doctor, who's contested the case for the petitioner by filing the respective affidavit. Mr. B. Chaudhary for recruitment. Yes, for state level recruitment commission. You are only for direct recruits. Council will respond more particularly. For filling up the post of secretary. Process was to fill it up by way of promotion from the interest seniority list maintained for the Gaon Panchayat. So, however, with effect from the date section 140 within bracket 1.
That was one time measure, no special circumstances. I have like in paragraph 13 of my application.
So how was it filled up earlier?
But for my not special circumstances, it was promoted.
Right, then earlier to that, how was it filled up?
I don't know such things.
No, but how were the posts filled up?
Why not?
Directly to promotee, deputation, how?
Promotion.
That's what we are saying.
Yes. But not on regular basis. One time measure that was
One time measure
on promotion.
from
Yes.
for which year?
Why not? That
Was
not
earlier done
specifically
by,
mentioned.
huh?
Not specifically mentioned.
Then how can it be one time measure? The posts were filled up by promotion, largely. However, after the amendment of section 140 within bracket 1, scope for filling up the post of for promotion has been done away with. The responsibility has been given to the state level recruitment commission for grade 3 and state level recruitment for grade 4 for filling up the posts, various posts into the Gaon Panchayat by way of direct recruitment. And as a consequence thereof, we have to keep that recruitment taken soon. Referring to 1, Mr. Doctor submits that it's clear that the recruitment process has been are to be conducted by the state level recruitment commission for grade 3 and grade 4 posts as constituted. And he also refers to section 30 of Act to submit that the staff of the Gaon Panchayat are to be filled up as provided under section 140(1). So therefore, the claims of the writ petitioners that there is no clarity in the amendment brought in, and therefore the claim for promotion is required to be considered, is contrary to the act read with the rules. In further disputes, the interpretation sought to be made by the counsel to the petitioner under the proviso to rule 4 that it governs the manner of recruitment by way of promotion posts of the various posts of the Gaon Panchayat into the post of secretary. So submitted that once the section once the provisions of the act have been suitably amended, it's the act which will govern the selection and recruitment process. And the rules will accordingly have to be read. Have to be read in terms of the amendments brought in. So further submitted that the interpretations ought to be made by the commission, therefore not correct. There will be dismissed. Council, he has also placed before the court judgment rendered by coordinate bench in WPC 6226 of 2022 by order dated 11/2/2026, submitted that this judgment is also clarified that the recruitment to grade 4 posts are to be undertaken as per section 140 within bracket 1 of the Act of 19. There are 2,000 parties have been heard. I would like counsel for the petition. So, these people report orders passed by coordinate bench. Submit that there are instances where litigants would approach this court seeking promotion. So, secretary, yes, were earlier given promotion and thereby rendering their reputation infructuous. Passed in WPC 5680 of 2010 by order dated 11/10/2010 and 31/5/2017 by which the petition is closed. Fact that the government has taken steps to promote petitioner's debut. What is the other order? Viswajit Das, this case. Party within our. It's necessary to refer. This section was amended. October prior to its amendment, there is under section 30. Yeah. Section, that by way of any specific orders, notification that the process for recruitment store secretary, Town Panchayat, was essentially filled up by way of promotion. There appears to be no dispute that there are several instances where the post of secretary, Town Panchayat, came to be picked up by promotion. Judgments, the orders which are placed before the court by the petitioner really reflects the tendency of the writ petition. Orders were passed by the state for filling up the post of Town Panchayat secretary on promotion. So, submitted that by the state council that as a one-time measure, some posts were filled up by way of promotion. Pursuant to the amendment of Rule 140, it's clear that start to be filled up by the recruitment process undertaken by the state level and state level recruitment process. Section 30 the Act also provides that staff of the Gaon Panchayat, secretary and other such staff shall be appointed as provided under section 140. And not service rules. So in fact, there is no service rules governing service conditions of Gaon Panchayat secretary. There is been under 9 governing the service conditions of Panchayat secretary. Therefore, the parties before the court sought to interpret section 140, that be section 30, and how the section and the rule are required to be read. Senators have attempted to interpret section 30, then section 140, 1, and rule 4, more particularly proviso to the court. Submit that an intercess seniority is to be maintained by treating the district, by treating the Gaon Panchayat district in one unit. By treating the Gaon Panchayat of a district header, but then their promotion from lower rank to higher rank shall be considered inter area according to the seniority of such a person. State on the other hand sought to interpret section 141 to submit that so by way of direct recruitment in terms of the procedure prescribed under section 140. Proviso 42 does appear that there is a provision for processing for filling up for the purposes of filling up a post on promotion under particular Gaon Panchayat, and for which purpose that Gaon Panchayat under the district is to be done. Gaon Panchayat within a district is to be considered unit of the district header. However, the amendment carried out to section 140 1, section that process for recruitment is to be undertaken as prescribed under section 141 by the district level recruitment commission. There is no material that prior the amendment of section 144(1) required or where sought to be picked up by the department by conscious decision. And thereby the petitioners have accrued a right to be considered promotion in respect of the vacancies which were available prior to the amendment. So no such material is split. The other see that tax collector earlier they used to be section 141 in bracket 1 section revenue appears to matter. There is a conflict between statute and the subordinate legislation. The Assam Panchayat Act of 1994 and the Assam Panchayat Administrative Rules of 2002. Provisions of the Act must prevail. Therefore, unless as the rules, as the section 140 or any other provision is not under challenge within the scope for the court, there is no necessity for the court to embark for any interpretation. Applicability section 1401 read with section 30. Therefore, the claims of the petitioners seeking a direction for setting aside or interfering with the advertisement dated 10/2023 case and the challenge made cannot be accepted in facts and circumstances which are urged. Let me further prayer that 60% of the vacancies for the post of Ground Panchayat out of the 944 recommended posts be reserved to promoted petitioner by way of while the claim of the petitioner challenging the advertisement and for reserving 60% of vacancies for promotion. Are required to the extent possible. That laying down the importance of providing the question of therefore, notwithstanding the rejection of the claim, file any appropriate ventilating the advance for such policy decision to be taken at the level of the government for observing for inclusion of promotion as another avenue for available Gaon Panchayat secretaries in the cadre of Gaon Panchayat for the posts in the cadre of Gaon Panchayat. This petition stands disposed of in terms of the above. And so far as recruitment, there is no claim against them otherwise. Any interim orders passed earlier stand vacated pending I. How many petitions? Three. So it is from 2014. 14. Okay. You give your respective names to the court master.
Lordship, in fact, there's one more matter which they have filed recently. All it's a big chain of events right from 15 to this.
What is the challenge here?
Regarding
Not just that, Lordship, it's the grading, which is a grading which they have given. ACRs have been communicated all right. Anyway,
So the pleadings are exchanged.
only in the new writ petition, the pleadings. Reply is available.
you have not which one? 26, I have to file it. That is not before your Lordship.
So you want these matters on some other date?
On 23rd
June. It has to go to July.
Even the other matters which in fact.
14th.
Huh? When is June? Khula lage lage no bhai. हाँ 21st of July. 21st of July, Lord.
These items are connected, submitted at the bar. But there is one more matter which is required to be put together. The WPC number
1635.
1635 or 26?
25.
25.
Yes.
26
1635 is here, the new matter.
2237 or 26.
2237 of 2026, which is to be listed along with these matters accordingly. It's agreed to let these matters be listed on 21st of July. The respondents, the parties are permitted to exchange their pleadings.
Okay.
Okay.
It's rule is issued in the matter. For admission or hearing. Rule is issued already. What is the matter?
My lord, the questioner is my lord, the ex-constable, my lord, and he was my lord, the dismissed from service, my lord, due to my lord, the unauthorized offset. But accordingly, my lord, he filed my lord, statutory appeal, my lord. The appeal was also my lord.
Where is the order of the?
My lord, special order, my lord.
No, the inquiry.
Inquiry report, inquiry, my lord, page,
Report.
inquiry, my lord, page, one eighty-two, my lord.
182.
182, my lord. Well, report, my lord, he was not, my lord, still, my lord, on due time, my lord. After 6 days, my lord, he is.
182 is what? This is the convening order.
Someone, my lord.
Acha, this is inquiry by the court of inquiry.
Yes. Code of inquiry. Code of inquiry, my lord, what is it, my lord, petitioner is the, my lord, only, my lord, sole caregiver, my lord, where, my lord, petitioner's mother is the whole.
No, tell us the merits of the matter. What are the grounds on which you have been
My
terminated?
lord, kindly see, my lord, dismissal order, page 36, my lord.
36. Yes.
Page 36, my lord.
You are appointed under what? SSB.
SSB, my lord, constable, my lord.
SSB Echo. Yeah.
80/2025, my lord, the dismissal order, my lord. May I read, my lord?
Yes.
Subject, my lord, subject dismissal from service under Rule 21 of SSB Rules 2000. Whereas UN number 20, my lord, Constable Amit Kumar, 15 Battalion SSB Kajalgaon, absenting from duty with effect from 15 June 2020, without prior permission of the authority, have been confirmed by letter dated 11/2024. Whether did you or did you submit reply? Court of inquiry was heard by order number 20, dated 5/11/2024 under the service record hearing number 20. Whereas number 13/1/2025, they submitted an application. Whereas on 18/1/2025, we submitted another application. Corrected to without call on the memorandum number 20. 21/1/2025. Whereas on 24/1/2025, again submitted an application and which was considered whereas after giving ample opportunity for reviewing the at order number 20, dated 20. By actions of sensitive to dismiss from service from under Rule 21 of reply to the state show cause notice or received by your letter.
Hey, where is the show cause notice?
Yes, my lord. First show cause notice, my lord, kindly see. Page, my lord, Page one, was page 81, my lord. Page 81. My lord, against was notice, my lord, page 83. My lord, why, my lord, he is unable to join, my lord, after completion of the, my lord. And they also, my lord,
Where is the order of declaring you a deserter?
my lord, my lord, everything.
270.
My lord, in affidavit.
Hmm?
My lord, 27/1/2020.
Then what happened against this? Any appeal?
Appeal file, my lord, appeal order, my lord, kindly see page 177, my lord. Dated, my lord, 23/5/2025, my lord. One, my lord, interesting point, my lord. Signatory authority, my lord. My lord, kindly see for a moment, my lord, page 181. Signatory authority is the second in command, no? On behalf of, my lord, the appeal.
No, this is an order. This is an appeal against the order of dismissal.
Filed by the-
Against the order where you are declared a deserter. Have you filed any appeal?
That or not, my lord, after dismissal order file, petitioner file is statutory appeal. My lord, next term, my lord. Next term,
Page
page
177.
One, start from 39.
So what is 177?
177, my lord, is a conveying order after my court of inquiry, my lord, which was not received by the, my lord, petitioner on due time, my lord. After 6 weeks, my lord, he received. Kindly see the, my
No,
lord.
177 is the order in appeal.
Yes, sir. 177 is the order. It was also rejected. My lord, kindly see the last page, my lord, page 181, my lord. Appellate order. Where, my lord, the signatory authority is the, my lord, the subordinate officer of the, my lord, appellate authority. This is not permissible.
Where?
Because, my lord, the still filed before the my lord, the deputy inspector general respondent number 4. My lord. But the signature authority, my lord, here, my lord, second in command, who is the my lord, Junior, my lord, the that authority. My lord, dear lord, no, my lord, the appeal remedy, my lord, the statutory remedy, my lord, but they don't, my lord, consider my lord in appeal, my lord, in a casual manner. Regard, my lord, I have one, my lord, the certification, my lord, but please allow me, my lord, to come. Subordinate officer cannot, my lord.
Is there any finding, recommendation of the court of inquiry? Court of inquiry order or anything like that? Leading to the dismissal?
Court of inquiry, my lord. My lord, my lord, for a moment, on page 182, my lord, kindly.
You come to page number 36.
30.
36, second paragraph.
Whereas court of inquiry was ordered by member to
So and so.
uh,
And on the basis of the court of inquiry. So there are some findings of the court of inquiry.
Page 182, my lord, kindly. One eighty. Extra 7. Alam Mena of 15 battalion officer to conduct a court of inquiry to find out the circumstances when number 2 first from effect from 15th and 2022. Court also find out the issue the property of government entrusted to the individual or in arms of inquiry after at least detailed evidence on above terms and apparent then 2 points responsibility person done. The court of inquiry points responsibility the part of the staff incident. Court of inquiry then record evidence on hope or affirmation that it submitted by comply with wherever applicable necessary for recording query will be completed in all aspects. Will be forwarded. My lord, next is my lord, kindly there is promote, my lord, page 183, my lord. The my lord, the petitioner now. It is dated, my lord, 8/12/2024. Yes, my lord, next, my lord, next is my lord, page 184. Postal, my lord, petitioner, that is my lord, page 185, kindly see, my lord, it was received by petitioner, my lord, 15/12/2024. After she death, no opportunity was given, my lord, regard my lord, court of inquiry.
So where is the finding of the court of inquiry?
Finding, my lord, and then, my lord, they issued, my lord, dismissal order, my lord. Opinion of the court.
Yes.
Next, L.
41.
My lord, communicated to the, my lord, the authority concerned, my lord, due to my lord, is
What is the action to be taken under the circular at page 241? Mr. Goswami, what is the circular?
I have annexed my affidavit, my lord, kindly see, my lord, my reply, rejoin the affidavit, my lord, page 419. Yeah, my lord, there is a, my lord, minor punishment also, my lord, but my lord,
Where is the circular?
circular, I have annexed, my lord, 419, my lord. I rejoin the
Yes.
start from 416, my lord. It is, my lord, 21/7/2020. Circular number 3 of 2020, my lord. Kindly see page, my lord, 418, my lord, subclause 10, my lord. 418. And that if the individual fails to respond, the commanding officer shall pass the dismissal or removal order as given in Rule 21. Suggested format of dismissal or removal order is enclosed by the next paragraph. Rule 1, my lord, there is a, my lord, minor punishment also, my lord. Lesser punishment also, my lord, my lord, not for the follow this. Remember, my lord, we do mother, my lord, who was suffering from, my lord, hepatitis typhoid. And my lord, but for the concern, he repeatedly, my lord, reply to the, my lord, to my lord, is non-apparent. Concern, my lord, not. And they have, my lord, they admitted, my lord, that he, my lord, they are communicated to the respondent authority. Even, my lord, the respondent number 5, my lord, 15 Battalion, Shirang, my lord, here, my lord, in Assam, my lord, communicated to the Bihar, my lord, the nearest post of the, my lord, SSB, that is, my lord, 51 Battalion. 51 Battalion, my lord, also communicated to the local police, my lord, where, my lord, the local police, my lord, found that the petitioner was not, at that time, my lord, he was not available, my lord, due to his mother illness, my lord, where, my lord, the 60-kilometer distance, my lord, he got a treatment, my lord, for his mother. Their own, my lord, in their affidavit, my lord, they admitted that was not available and at that point of time. My lord, kindly see, my lord. Kindly see my agenda affidavit, my lord. Page 341, my lord. Find in the police Sitamarhi, my lord. Subject, my regarding the absence of Amit Kumar, son of late so resident of so, with reference to the above subject and details, it is respectfully submitted that the search was conducted at the residence of Amit Kumar, UN number son of resident of so, who has been absent from 15 Battalion SSB Kajalgaon since 24/4/2024, and his house was found locked. On inquiry with nearby villagers, has gone out for his mother's treatment and has not returned home for several months. When contacted on his mobile number, Amit Kumar stated that he is currently staying in Raghunathpur, Sitamarhi for his mother's treatment under Dr. Rajesh Kumar, as his mother is suffering from typhoid, jaundice, and stomach pain and has been undergoing treatment since October 2024. He is unable to walk properly. Further informed that he has two brothers and his younger brother, Shivam Kumar, who has Ludhiana, is addicted to intoxicants and does not take responsibility to the family. Due to which Amit Kumar is the only caretaker of his mother, he has assured that he will February 2025, and the above information is submitted for your client. Their own interdepartmental communication matter. And next matter, kindly see the page 344 matter. 1 Battalion SSB Sitamarhi minor. Nearest post of the minor, the residence minor to 15 Battalion SSB minor. Please refer to 15 Battalion SSB wireless message number so minor who has been absent since 10/2025. He physically verified by sending a representative to his home and that a report be submitted regarding the reasons for his absence without any information permission. In this regard, it is informed that a representative from his office was sent to the residence of the above mentioned personnel. During the verification, Constable Ramesh Kumar stated that he has not been able to report to the 15 Battalion headquarters mother's ill health, which is true, and that the medical documents related to the treatment have already been forwarded to the battalion headquarters. So,
There is the opinion of the Court of Inquiry, 241. Is it? Forty-one. Where is the order declaring you to be a deserter?
272 man. Sorry. 70.
7.
270 minor. Next minor in their affidavit of post mortem. 70.
Seven. Provision under the rules, procedure.
File minor under rule 29 minor. The 21 minor. Minor termination of service of persons other than officers on account of without leave, my lord. My lord, section 20, Act 2007. One small fee minor without sufficient cause overstays leave granted to him. Minor to communicate the authority minor to very minor done minor. Under compelling circumstances, minor fee was not minor. That time minor was not ready. Prisoner order minor passed by the honorable court minor is lordship allowing the page 120 minor kindly see minor. Only minor the disease are different minor. Same minor the constable of minor SSB minor. Is 120 my week minor kindly. Minor. The requisites are herein full joined with the Samaksa Simabal of the Constable General duty on 22/7/2006 at the 22nd Battalion of the SSB Raniganga. After serving at various places, the petitioner was posted at Kadalgaon under the 15th Battalion of SSB at Kadalgaon, the district of Chirang on 19/6/2017. While serving at Kadalgaon, the petitioner had applied for 31 days earned leave with effect from 10/1/19 to 19.
You are reading from?
Yes, 121. One paragraph 2, madam. Facts, madam. With permission to avail suffice on 10/2/2019 for medical treatment of his ailing mother, madam, who at the relevant point of time was suffering from liver cancer, madam. Facts to the same, my lord, the honorable court, my lord, allowed the restitution, my lord. Paragraph, my lord, that point of in this case, my lord, also petitioner was the, my lord, sole caregiver. Here, my lord, in this case, also, my lord, petitioner was sole caregiver. What my humble submission, my lord, the petitioner, since my lord, petitioner is no opportunity, my lord. And the proof that this noble court also, my lord, passed one judgment, my lord, I have next, my lord, says, my lord, 104, my lord, can you see, my lord? Paragraph, my lord, 20, my lord. The view of the matter, this court doesn't consider it necessary to examine the legality of the subsequent action taken by the authorities after the holding of the court of inquiry as to whether these were done in accordance with law or not. For the reason of that, this court has already found that holding of the court of inquiry on 21/9/2011 is vitiated on account of non-intimation of the holding of the state court of inquiry and also non-providing of the opportunity of the petitioner as mentioned. Sub-rule 8.
Paragraph 20.
Paragraph 20, paragraph 4, sub paragraph 20. But all these judgment petitioner stated in there is appeal, my lord, but not considered by the appellate authority, my lord. My lord, kindly see page 110, my lord. 110, my lord, Krishnakant B. Parmar versus Cinema of India, my lord. Paragraph 17, my lord, kindly see, my lord. If the absence of is the result of compelling circumstances under which it was not possible to report or perform duty, thus absence cannot be held to be willful. Absence from duty without any application of prior permission may amount to unauthorized absence, but it does not always mean willful. There may be different eventualities due to which an employee may abstain from duty, including compelling circumstances beyond his control, like illness, hospitalization, etc. But in such case, the employee cannot be held to failure of devotion of duty or behavior unbecoming of a government servant. In a departmental proceeding, if allegation is of unauthorized absence from duty is made, the disciplinary authority is required to prove that the absence is willful. In absence of such findings, the absence will not amount to misconduct. Filed matter is statutory appeal, but statutory appeal may not considered in schedule like schedule exercise and not proper application of minor. My lord, kindly see this regard, my lord, in rejoinder affidavit, my lord, page 397, my lord. I have next one judgment, my lord. The property is Saroj Kumar Sinha.
You have enclosed in
My rejoinder affidavit, page 397, my lord. Paragraph 30, my lord. 29.
no, first tell us the sequence of events. After you were found to be absent without leave, there was a court of inquiry convened. Court of inquiry gave an opinion that the proceedings should be steps should be taken in accordance with that circular. Thereafter, what happened? You were declared to be a deserter. Then show cause was issued, which you claim that you did not receive.
But I have submitted my reply also.
Reply. Everything is everything prior to the dismissal order. Is there any other order showing that why the department refused to accept your explanation? Any order? Okay, Mr. Goswami.
Next to the affidavit of opposition. We will proceed with the annex of 1, Malak. There is a resignation letter by the petitioner. That is on 18/8/2024. Case 228. Immediately after the receipt of the resignation letter, the domestic problem, then because we train up the person who incurred use government money. That is why we wrote a letter on 13/9, that is next annex 238/30. We ask him to deposit this amount. Anyway, sir. And
When did he take leave?
first leave, prior to that, he took leave initially on earlier occasion. That is annex C, It was granted subsequently extraordinary leave
Annex D, my lord, for 26/9/2024 to 18/10/2020. The joint, my lord, notice was issued, Annex I, 26/10, page 233, 26/10/2024. Again, reminder, 237, please. And that paying order for Court of Inquiry is 239.
But here, submitted his reply expressing the reasons why he could not join.
Opinion of the
where
Court of Inquiry is on 13, dated 13/12/2024, page 241. For the procedure on the plates annex 232/42, the remark of the commandant.
After you asked him to rejoin,
Oh.
he submitted some replies, representation, expressing his difficulties as to why.
Initially, he was not responding.
Huh?
Initially, he was not responding. They not able to contact him. He wrote letter.
Why did you resign?
But that reason was withdraw, my lord.
Huh? When was it withdrawn?
Others, my lord, due to my lord, business, my lord, sometime, my lord, then, my lord, their dismissal order, they admitted, my lord, in the 2025, and exactly 30, this is communication, his reply, my lord. On 13/1, my lord, after Court of Inquiry, then 18/1, my lord, then 24/1. My lord, 13/2/2020.
You're saying the dismissal order is the referred.
Yes, sir.
Where?
Page 36, my lord, 96.
Huh?
Page 36, my lord, petition, my lord. Fourth pada, my lord. Whereas on 13/1/2025, you submitted an application and intimated that you to death of your mother, to unable to resume your duty, and also intimated that as and when your mother recovered from illness, you will report at battalion headquarters. Then, my lord, kindly see next page, my lord, 37. Whereas on 18/1/2025,
my lord, event, my lord.
then, my lord,
2025, he replied, my lord.
Their, my lord, own communication, my lord, interdepartmental communication, where, my lord, 15
The opinion as a Court of Inquiry was earlier, my lord, in December 2024. Since we have not able to contract him, that is why the Court of Inquiry.
their own communication, my lord. My register affidavit, my lord, can my lord concerned with my lord, Sitamarhi, my lord. Page 343 and my lord, 345, 344, my lord, kindly see. Not found due to my lord, mother's illness.
No, because of your mother's illness, you are at home.
Not from, that is why, my lord, 60 kilometer distance, my lord. I have stated my petition, my lord, paragraph 5, my lord. Kindly see my paragraph, my lord. From my native place, my lord. That is why, my lord, I have not received, my lord, some communication, my lord. My lord, paragraph 5, my lord, kindly see, my lord, that the petitioner especially requested that as the leave was obtained by the petitioner for medical treatment of his mother at Raghunathpuri, Sitamarhi, Bihar, which is situated 60 kilometer distance from the native place of the petitioner. The mother of the petitioner was seriously affected from the disease, typhoid, hepatitis, and jaundice. The concerned doctor advised him to take complete bed rest and required constant observation of his ailing mother during the course of treatment, so that
court at Mohanpur Bazar, care of Ravindra Center, that district of Sitamarhi, Bihar, which is 5 kilometers away from the chamber of concerned doctor. It's pertinent to mention that he is only a caregiver of his widow mother, though he has a younger brother, but he is intoxicant and refused to responsible. So under such compelling circumstances, the petitioner has no other option but to serve and care of his widow.
So Stanley, look into base 251 as well as the 259. These are the momentum and directed the petitioner to resume duty. In this communications, it is clearly revealed that petitioner is not the sole member in his family.
Where
The
is-
service record,
Hmm.
this communication is clearly mentioned. Well, third para onwards, 251. And whereas remaining absent from leave and overstaying leave in the offense under so and so, because civil authority to assist in the arrest or forcible custody of the purpose. Therefore, based on the recommendation of the inquiry and with the approval of the committee, these officers requested the superintendent of police, Sitama, to apprehend you at the earliest, recover your service identity card and hand over your custody to the undersigned nearest assessment. And whereas on so and so, you send a letter informing that due to your mother's medical treatment, you are unable to come to the battalion headquarters, and that you will make your presence at the battalion as soon as your mother's health improves. But as per the family details recorded in your service book, you have a younger brother who is unmarried and can take care of your mother in your since currently been absent from leave for more than 60 days without permission from the commission authority. Therefore, indirected to the likewise in the 251 month, again 259 month, again 21 1 21 was written in put back the battalion. But even though he failed to respond, it is duly communicated to him of given an access. Deliver it not only this time, on the earlier occasion also he is absent from the duty more than the leave period. And of course, those occasion is that was when they will regularize. That will be reviews from 308 page. The alia occasion leave that has been regularized.
But where is there has to be some assessment for the authority to decide that he is not fit to be kept in service.
The court of inquiry followed opinion. The commandant 242 remarks on basis of the court of inquiry opinion this remark. It's clearly mentioned. Reveals 242 page. They have placed the relevant record before your lordship.
Is it not available in the paper book?
Well, it's available, but since the order is there,
Where is that? In
the
the paper book? In the pleadings?
annexer M242, the commandant remark of the commandant on the
42.
Well,
Where is the finding of the court of inquiry?
the earlier page 241, opinion of the court of inquiry. And court further recommends that. Jealousy is already gone through it,
But they say that he did not make any communications. According to the petitioner, he submitted some communication.
Manoj, the find that court of inquiry as well as the remark on the court of inquiry dated 30/12/2024. Prior to that, he was not communicated with this department.
Where
He
are the medical
communicated
documents of
after
your mother?
2025 January month.
And it is based, my lord, it starts from 144, my lord. 144, my lord.
Commandant wrote a letter to the SP on the annexer 244, annexer O, my lord, dated 2/1/2025.
This, my lord, reflects on page 152, and my lord, page 151, and in 1.
There is a communication from the commandant to the SP to apprehend the petitioner. My lord. Hereafter, my lord,
Manner of the disease, my lord, respect, my lord,
again, my lord, it is.
Where is the medical opinion?
And command that petitioner wrote a letter annexer X S 249. That is 12 January 2025. Prior to that, no communication. The court of inquiry held prior to this month. Accordingly, the memorandum dated 17/1/2025 is directed to report to the headquarters of the battalion. But why is such kind of letters or wrote the petition about he did not.
Court of inquiry
27
opinion is very skeletal. Court of inquiry's opinion very skeletal. The court of inquiry has opined that he is unauthorized leave. Or there is only on
It is
the
apparent from the documents annexed to the affidavit as well as the record before your lordships. Prior to December January 2025, he never reported the headquarters. He is a armed force personnel. It's his duty, at least intimation. Then after repeated, he himself knows he remained absent beyond his leave period. He should have intimated.
How many days of absence? It's a total number of days of absence.
More than 60 90 days.
He was given leave for how many days?
How many 15 days?
15,
15,
1 5.
from 26/9/2024 to.
And you remained absent for 90 days.
So 2025 onwards the communication. The department is lenient view, madam. I asked him to report it, madam. Even though he wrote, madam, here from the communications it reveals. He refuses, madam.
When is the first communication you received?
Madam, page, madam, 250. 249 in the English version, madam. Anikana is 250. madam. He wrote Annexa S.
His period of leave was from which date? Where is the certificate of leave?
Excerpt 2, page 35. It was done on 25/9/2020.
6/9 to 18/10.
And when is your first communication?
12/1, my lord.
Page?
It might not. My rejoinder, my lord, is 341, my lord.
When is your first
Final
communication?
41.
241. What is the opinion?
249.
249, sorry.
Yeah.
Like, madam, paper publication also made, madam, in the own for calculated in the. A is
Page 2.
86.
86. This was in which newspaper?
Done.
Which newspaper?
Sometime, they didn't mention it in body of the.
You have to give an explanation as to why from.
Dainik Bhaskar, Malad.
Uh,
And
Does it have a circulation in?
Malad, that is why the
Patna,
population
Bihar.
within that area, Malad, where he is resident.
What is your explanation regarding the absence for that many months and not communicating? The department.
22.5.
You have been given a leave certificate, you know you are to join on 18/10, 24. You intimate your authority for the first time in 2025. Why? Huh? Huh? May not be, but you are a man of disciplined forces. Is it not your duty to intimate the authorities within time that you could not go and join because of these reasons? It is not a delay of 1 week, 10 days. October 2024. And you intimate in January. Why? What explanation have you got?
Our distance by the fund. And even by the their authority also by the meeting. I was not by the. I have an next minor that.
Forget about you not being present. See, it is in a given case, supposing you go on leave. You're on leave. You have submitted an application seeking leave. There was no order passed on the day when you went on leave. So you are not aware whether your leave was sanctioned or not. Until you are intimated by the authorities that your leave is not sanctioned, etc. Here is a case you have been given a leave certificate. You know from X1 to X2. This is your leave. Your mother required treatment, fever treatment, but does it require you to respond for more than 3 months, not to respond?
Of inquiry by not after 6 days by not 185. Court of inquiry summon my lord. After 6 days, phase 185 my lord. Someone was my lord issued on 8/12/2020. Next my lord, where is my lord someone appeared in someone my lord, it is 12/12/2020.
Also, my lord. And my order, my lord, not my lord, really, my lord, and the supporting officer is half of that. But allow me, my lord, but one. Officer cannot. Bharat, my lord, kindly.
What do you say, Mr. Goswami, with this office memorandum?
Not on behalf of my lord.
Is it binding on SSB?
My lord,
Yes, my lord, the central court.
or my lord, AIG, my lord. Signed by board.
Can it be done? When the hearing was purportedly done by some authority. That we have seen.
Department took always lenient view, my lord. Earlier occasion also, my lord, when he sought to appear for some other organization
permission was given to him. And accordingly, he obtained a order from the honorable court. So, मतलब, he had just going himself to be going under the disciplinary force, मतलब. And then, मतलब, although there are other family members to be extended, stand on negligence, मतलब, always cannot be.
Where are the other instances discussed? Said earlier he was also absent. He overstayed his leave, earlier occasions.
मतलब, in fact, मतलब, results from that particular मतलब, document whereby that annexa annexa AR मतलब is 308 मतलब. Annexa 308
Annexure 30.
मतलब AR 308 page. That has been मतलब worse that has been regularized very difficult.
This is a deserter. You're referring to 308.
मतलब office order dated 25 मतलब 9 or 7 2024 24. चलो
From the sequence of fact, it appears that you are not very inclined to resume your services. See the discussion of the appellate authority at page 180, serial number P. Inform the authorities that you will report back after restoration of the health. What is the meaning of that? You are already, you have overstayed your leave by well over 3 months. Months. No, 3 months. And see the reply you are giving after restoration of health. What will your commanding officers make of that? That you are not inclined. You are a member of a discipline force. Here are the punishments here. You are dismissed from
service.
dismissal from service under Rule 21. You are serving as what? Constable. So there can't be a lesser punishment or reduction of rank. You are at the lowest rank. Dismissal or removal. So the only other punishment would be compulsory retirement. How many years of service have you put in? 22. For 3 years. You are not entitled to pension also.
Five,
22. 3 years. Minimum 10 years is required.
My lord, 421. Where my lord, petitioner, my lord, permission, my lord. Here, my lord, the sub-inspector of post, my lord, putting my lord qualified. And now, my lord, due to my lord, an order, my lord, not my lord join, where my lord criminally convicted person from pass in one order, my lord, and next, my lord, is 230. 37.
Seven.
437.
This writ petition is also listed today.
$22. Interim order given this. Yeah, I am.
Pass my lord for there, my lord, NOC.
So we are not interfering with the dismissal order. But yes, the appellate authority order is not as per the memo.
Honorable Court, my lord, past, my lord, case, my lord, 120, my lord. Circumstances, my lord. That the case 127, my lord, the court is part, my lord, paragraph 13, my lord. Here, my lord, the petitioner's mother was also, my lord, suffering from disease, my lord.
We are not interfering with the dismissal order because of the simple fact of your conduct. But the fact remains that the appellate authority also did not follow the rules. So maybe we'll remand it back to the appellate authority to redecide the appeal and pass any appropriate.
Under compelling circumstances, my
No,
lord.
it doesn't appear to be compelling. You are overstaying on leave for more than 3 months. Your reply is that you will go and join as and when she is back to health. You have also applied for CRPF recruitment during the currency while you were in service.
My lord, the year 2024, my lord, advertisement was.
Whatever, while you were in service in SSB,
Sure.
was any NOC required?
That was issued, my lord. According to the petition, my lord, exponent, my lord, give permission, my lord, to appear, my lord.
That will follow its own consequence. Heard Mr. Helen Dehania nothing.
That's one, my humble concern, my lord.
UK Swami learned CPC for the response. Yes.
My lord, I just very, my lord. One, my lord, Arab.
This is pertaining to what?
But also, my lord, the on the alia case.
You don't fall into the category because you applied for CRPF, getting in NOC. So you don't belong to that disadvantaged strata of the society that you were not aware of what consequences would follow. You're perfectly aware. You're not happy with this job. It's your call. But to project yourself as somebody so helpless who doesn't know what is going on, what consequences are there, we are not convinced. But yes, your argument that the appellate authority did not sign the order appears to be correct. You can remand it back for the appellate authority to decide, re-hear and decide the appeal.
Inquiry, my lord, on not my lord, due time, my
Hmm.
after 6 days,
So
my
they
lord.
will examine him. Beyond that, we are not inclined to say anything. Third counsel for parties. This writ petition is directed against the order dated 8/3/2025, passed by the disciplinary authority dismissing the petitioner from service under Rule 21 of the SSP rules 2009. So, the petitioner was appointed as Constable GD, the SSP. In the year 2022,
5/5/2020.
5/5/2020. Stop. During the course of his service, the petitioner applied for and was granted the for the period from 26/09/24 to 18/10/2024. This was by leave certificate issued by the raised by the competent authority on 25/9/2024. So petitioner thereafter proceeded on the stop. As per the leave certificate, he was to report back on duty on 18/10/2024. So, thereafter, the petitioner did not report back on time, and consequently, communications were issued by the SSB authorities for directing the petitioner to resume his duties. However, since the petitioner did not resume his duties, a court of inquiry was instituted under what section? Under the provisions of the SSB Act 2007 Regulatory Rules. So, the court of inquiry was convened on 5/11/2024. Stop. Copies of these.
Also, my lord, date, my lord, controversy, my lord, kindly see, my lord, where, my lord, then, my lord, 5/12, my lord, somewhere, my lord, 5/11.
5/12, my lord.
On 5/12/2024, and the same was duly intimated to the petitioner as per the was stated to have been intimated to the petitioner. Stop. For the petitioner submits that these communications were never received. So, according to the petitioner, he could not join in as he was a caregiver and the mother who was suffering from serious ailments like jaundice and hepatitis and typhoid. So, court of inquiry thereafter rendered an opinion dated 13/12/2024, recommending suitable action to be undertaken with respect to the petition. So, accordingly, by order dated 27/1/2025, the petitioner was declared within courts, deemed to be a deserter. Courts closed. Stop. The thereafter show causes were issued to the petitioner, calling upon him to show cause as to why punishment sought to be imposed should not be imposed. The petitioner, as per the show cause. As to why action to dismiss or remove the petitioner from service for the misconduct should not be initiated against the petitioner under Rule 21 of the SSB. So, the learned counsel to the petitioner submits that none of these communications were received by the petitioner, therefore respond in time. Submit, file any reply to the show cause.
Yes.
Where is that?
First show cause notice, my lord. First show cause,
28/1.
page 81, lord. Then, my lord, can you see my reply, my lord, page 83.
Petitioner filed his reply.
13/2025. Page 1, 2025, and my reply on 13/2, my lord.
filed his reply on 13/2/2025, explaining the reasons why he could not rejoin his duties. So, the authorities thereafter upon considering the materials available and the opinion of the Court of Inquiry, disposed of, completed the inquiry, passing the impugned order of show cause, impugned order of dismissal against the writ petition. So, by the impugned order of dismissal, the petitioner was dismissed from service. And the period of unauthorized absence with effect from 18/10/24 to 18/3/2025 was directed to be treated as non, as non. So, whereas the learned counsel for the petitioner submits that the very initiation of disciplinary proceedings is contrary to the inquiry did not arrive at the conclusion of dismissed. Convening orders of inquiry were received by the petitioner. Therefore, petitioner did not aware that the court of inquiry is conducted and the petitioner is required to be present. So, it is further submitted that the disciplinary authority did not examine the case of the petitioner in the proper perspective, and there is no finding by the authorities that the stay on leave was not deliberate, but for reasons beyond its control, which was the illness suffered by his mother, as he is the only caregiver of the family. And he could not mother treatment. So, the learned counsel to the petitioner, in support of his contention, has pressed into service the judgment rendered by the apex court in Krishna Parmar, the court of justice, as also judgments rendered by this court in so and so. And the further contention of the counsel will that the appellate authority heard and dismissed the appeal filed by the petitioner, not the appropriate authority, as under the SSB Act, where is the provision for appeal?
59.
Rule. Under the 29 of the rules, the appellate authority worked for dismissal of services. So the authority higher than the one who has passed the termination order. So, in respect of the petitioner, termination order issued by commandant, therefore the appeal. DIG, not direct, Deputy Inspector General. However, the appeal was dismissed by order dated 23/5/2025. However, but the signatory order, second in command, in bracket EDM, the station headquarters SSB, for for and on behalf of the DIG, station headquarters, SSB. Learned Council submits that bear reading of is that the appellate authority is the Deputy Inspector General. The order was signed by the second in command for and on behalf of the Deputy Inspector General. So, the order itself, there is no reciting that the second in command was duly authorized by the appellate authority, namely the Director Inspector, Deputy Inspector General, act as the appellate authority and sign the order. So, further, during the course of the hearing, counsel to the petitioner has placed before the court the office memorandum dated 13th of July 1981. Submit that as per this office memorandum, the issued by Government of India, Ministry of Home Affairs, Department of Personal and Administrative Reforms, that disciplinary slash appellate slash reviewing authorities exercising quasi-judicial powers cannot delegate their powers to subordinates. Stated therein that the decision taken by such authorities are communicated by the competent authority under their own signatures. And stop this order, the office memorandum still stands and is effective. Therefore, the impeachment order of the appellate authority is conflict with the office memorandum. So therefore, also interfere, set aside and quash. Mr. U.K. Goswami, learned CGC, appearing for the respondents on the other hand, strongly disputes the contentions made by the petitioner. He submitted that the petitioner was well aware of his period of leave and the date on which he was supposed to report back, as it is mentioned, clearly mentioned in the leave certificate. So, further submits that several notices were issued to the petitioner and orders for resumption of duty was issued to the petitioner, but he did not the same and did not resume his duties. Stop. The counsel for the petitioner counsel for the respondent submits that there was a deliberate and willful disobedience of the commanding officers' instructions to the petitioner to resume his duties. Stop. The CDC further submits that petitioner deliberately petitioner was not the only sole giver, not the only caregiver to his mother, and his family comprised of his brother and other family members. Therefore, the contention that he was the sole caregiver is not correct. So, it is further submitted that the notices and requisitions issued by the SSB, the petitioner, asking him to rejoin his was deliberately evaded, and therefore the petitioner willfully and deliberately overstayed his duty. So, learned counsel for the SSB is also produced original records. counsel for the parties have been heard, pleading is available on the court. The petitioner from the report, it is seen that the petitioner was issued a leave certificate, wherein the period of his leave is clearly mentioned. So, the petitioner, the projection given, the contention of the petitioner that he was the caregiver of his mother and ailing mother, and that he was and his mother was under treatment at a place which is 7 kilometers away from his place of residence as per the records of the SSB. Thereby, he had to stay in a different place, closer to the place of treatment of his mother, and therefore did not receive the says and the instructions issued. Stop. From the records, first communication issued by the petitioner expressing his difficulty in rejoining was on 12/1/2025. Stop. Said communication, he intimated the SSB authorities that he is unable to join his duties as his mother is ailing and is under treatment, and he will resume his duties as and when he resumes his duties. As soon as our health improves. Stop. What has not been explained by the petitioner, satisfaction of the court, is that with effect from 18/10/25, 24, 12/1/25, when the petitioner submitted his first intimation as to why the petitioner on his own did not feel it necessary to inform his superiors that he is required to extend his leave because of the ailment suffered by his mother. So, it is also not explained as to why the petitioner decided to, whether the petitioner decided to issue the communication on 12/1/2025 pursuant to receipt of any notices by the department. Stop. There are medical documents enclosed to show that the petitioner's mother was on the treatment and of a doctor, of a local doctor, and treatment was underway during the safe period of time. Stop. The question remains as to why the petitioner did not or could not intimate the SSB authorities prior to expiry of his leave that his leave ought to be extended on account of the ailment suffered by his mother and the care that he is required to give to his infant. So, on the other end, this court is also has also noticed the Court of Inquiry opinion rendered against the writ petitioner on 13/2/2024. 13/12/2024. That it did not, that it was, that the opinion was rendered only on the ground that no correspondence or intimation the office was received. And therefore, suitable action was recommended as per provisions contained in FHQ SSB New Delhi Circular number 3/2020, read with SSB Act 2007 and the rules 2009. So, there is no application or appeal filed by the petitioner available on the record to show that the attempt was made to recall or set aside the order dated 27/1/2025, whereby the petitioner was within quotes deemed to be a deserter. While the petitioner has made an attempt to rely on the ratio laid down by the apex court in Krishnakant B. Parmar, Supra, and other judgments, submit that the overstay of the extension of leave was not willful, facts needed before the court does not sufficiently explain the inability of the petitioner to intimate his superior officers regarding the extension of his leave on account of his mother's ailment beyond the period of 10. So, the petitioner is not an illiterate person, and therefore he was quite aware as to the period in which his leave was expiring. So, as discussed, there is no explanation furnished by the petitioner regarding the deficiency of intimating his superior officers immediately before or after period of leave. Immediately before or after expiry of the period of leave as specified in the leave certificate. So, under such circumstances, the court not inclined to interfere with the dismissal order of the petition on these grounds. But having said that, what is necessary to state is also the fact that the appellate authority, having dismissed the appeal, having heard and dismissed the appeal, the order of the appellate authority was not signed by the appellate authority but by his second in command. This is in contravention with the Government of India this memorandum dated 13/8/1981. So the said office memorandum is extracted below. Perusal of clause 3 clearly reflects that it is the appellate authority who has to sign the office memorandum, who has to sign the orders, not by their subordinates as they are exercising quasi-judicial powers. Stop. It is also, the court has also considered the submission of the counsel for the petitioner that the act, the section 51, read with rule 21. What is the rule?
51.
Rule 51. Lays down several punishments. 51. 51 is record of it.
Take my note. Okay.
Section 51. Section 51 lays down several punishments. Therefore, taking into consideration the submissions made by the counsel for the petitioner that the dismissal or removal from service ought not to have been inflicted on the petitioner. Section 51. This court is of the considered view that ends of justice will be met. The order, the appellate order is interfered with, set aside, and the matter is remanded back to the appellate authority to re-decide the appeal filed by the petitioner and pass a speaking order duly signed by the appellate authority, namely the DIG, so and so. Stop. The appellate authority, while examining the case, will also consider the provisions, will consider the matter in the light of the law laid down by the apex court in Krishnakam v. Parmar, so far as the overstay of leave of the writ petitioner is concerned. So, needless to say, any such order that is passed, a copy thereof shall be served on the writ petitioner. Was there a further appeal or a review against his appellate order? Writ petition accordingly stands disposed. Ordered.
Time.
Records placed before the court are handed over back to the CBC. The appeal we decided within how much time? 30 days.
Oh.
We decided within 30 days from the date of receipt of a certified copy.
Hello. Plug.
Next to the appointment of
It took really well.
selection and appointment of Pangundbadi helper and workers. Terms of the lordship selection process, we have participated in the selection process. Accordingly, lordship, the panel list was prepared and submitted to the Director of Social Welfare for approval. The Director has got approved. Against the lordship, this present petition is filed, and in the affidavit proceed. The affidavit, the director has taken a that in the affidavit, the director has taken a step that for not granting approval, that since the rationalization process was to be carried out by the CDPO concerned, and after that, lawsuit selection process ought to be initiated. And since the rationalization process was not completed, that's why the approval was not granted. In fact, lordship, if your lordship kindly, there is the affidavit in opposition paragraph 4, only one paragraph, page 43, running page. There it goes.
Yes.
Paragraph 4. Page 43. Your affidavit. With regard to the statement made in paragraph 4 to 13 of the report, the document that stated that Site Development Project Officer Lala ICTS project issued an advertisement dated so and so for filling up the position of Anganwadi workers and helpers. Subsequently, the Site Development Project Officer Lala ICTS issued another notification dated 30/11/23, wherein it was stated that advertisement published on so and so for engagement of Anganwadi workers and helpers in the vacant post was cancelled, and fresh advertisement will be published after the completion of rationalization of Anganwadi worker centers of the project. Thereafter, another advertisement was published on 4/3/24. The Site Development Project Officer Lala so and so for filling up the position of 6 numbers of Anganwadi workers and 39 numbers of Anganwadi helpers and completed the process. The Site Development
What is the rationalization process?
Well, that process has already been carried out. After that, lordship, with the due approval of the director, this process was lordship completed from the city side. Lordship,
Now they are not issuing the appointment orders.
no, because the approval is not granted by the director.
Why?
Well, as per the lordship, the director of social welfare lordship, the rationalization process was not completed.
What is the meaning of rationalization process?
That means some amalgamation process was carried out. Some centers were together, lordship, and do that process. After completion of that process, lordship, the selection process was initiated. But the director.
What is this notification 30/11?
Yes, lordship, page 17, your lordship.
70
17. This was relating to earlier selection advertisement. That was cancelled in pursuance of Director of Women so and so Development Assam so and so, dated 22/9 November 23. The advertisement published dated 21/9/2023 by number so and so for engagement of Anganwadi workers and Anganwadi helper aiding the vacant post is hereby cancelled. A fresh advertisement will be published after completion of rationalization of Anganwadi center of the project. Subsequent lordship advertisement, page 18.
Page
18, next page. In pursuance to this advertisement, lordship selection process was carried out. And panel was submitted, lordship, that is case lordship 40. The Site Development Project Officer lordship has submitted the interview papers for selection of Anganwadi workers and helpers for approval.
Then?
That approval was not granted, and in the affidavit lordship, that stand is taken that before completion of rationalization process, the selection process was completed and sent it to the director, and hence lordship, the director has not complied with, has not approved. In my affidavit lordship, we have filed an RTI application, and in reply, the CDPO concern has lordship furnished some documented information. The lordship kindly come to page 51, running page in our affidavit in reply. Page 51. Point A. You have requested to provide the date on which rationalization process was completed, along with documents to that effect. In this regard, it is informed that rationalization process was completed, and the relevant office documents are enclosed herewith as Annexer A for your reference. Point B. You have requested to provide the reason in the event that the rationalization process was not completed prior to issuing the fresh advertisement. In this regard, it is informed that rationalization process was duly completed and the report was submitted to the director of so and so dated 10th July 2024. Thereafter, approval was received from the director Assam for conducting interview and taking necessary action. A copy of the approval letter is also annexed and closed here with as Annex B. Next page, your lordship, is page 52. This is the proposal submitted by the lordship CDPO to the director regarding completion of the rationalization process. After that, lordship, page 53, this approval was granted.
There are two affidavits filed by the
Yes.
respondent three.
Against this reply affidavit, lordship, after annexing this document, they have submitted an additional affidavit, lordship. This is the second affidavit, saying that page 53.
There are 4 centers to be yet to be amalgamated.
Yes, yes.
Yes, that
That
was
is
the
the,
start.
there is second affidavit, my lord, paragraph 4.
But
No, these are for appointment to which post? Anganwadi, helper and worker.
helper and workers.
So one of the condition is that you must belong to that area.
Yes, that is not an issue because only
Now, which are the centers which are yet to be amalgamated?
Yes.
Which centers?
centers, lordship, I have given in paragraph, lordship, 5 in my repetition. I have mentioned in the details of the center.
ICDS project of Lala ICDS project. There is for the
Lala-
36 center.
Para 5.
Para 5 in my repetition, page 5.
Which are the centers?
Centers, lordship, number 1, petitioner number 1 applied for the post of Anganwadi helper in Nice
No,
Garden.
we want to know, as per the affidavit, there are 4 centers left to be amalgamated.
Yes.
Which are these 4 centers?
My lord, these are out of, lordship, altogether, lordship, there are 49 centers there in the district of, lordship,
No, you are not eligible for 49. You are eligible for only those centers which fall within your area. Or
No.
you
No.
reside within those areas.
No, that was related. Rationalization process was carried out for entire district.
I don't know.
And some of the lordship, centers were
Uh.
amalgamated and some of the centers are leaving from amalgamation, saying that these are not necessary.
Now, so far as your area is concerned,
Yes,
what has happened to that center? Is it amalgamated, not amalgamated?
not amalgamated.
Not
because-
amalgamated. Where is the decision to say that it is not amalgamated?
But that is not in that affidavit also. But this selection process, lordship, was carried out after getting, lordship, the approval, lordship, page 53.
I have understood that. Your advance before the court is that there should be an order asking you to be appointed, permitting you to be appointed.
My lord.
Now the question is which Anganwadi center that you are asking for be appointed?
My lord,
Which Anganwadi?
my lord, our centers,
You
lordship,
can't be permitted to go into all the centers. No.
we are concerned only our concerned Anganwadi center because if a candidate cannot go beyond that area,
That's right. So all the 4 petitioners belong to different areas.
different Anganwadi center.
So in these 4 petitioners, they fall in the areas where the 4 Anganwadi centers are yet to be amalgamated. Is that the case?
That is the standard of the director, but lordship, the stand of the CDP is concerned that amalgamation process was carried out.
Complete.
Whatever was required to be amalgamated, that has already been amalgamated. And whatever is not necessary, that those centers were left out. So we are
Now, who decide, Mr. Surya, as to who is correct, the director or the CDPO?
Director has filed affidavit and said that there is no record. Whatever he stated before your lordship, there is no record and amalgamation is not completed. Out of 36 centers is
32
there,
are completed.
36. Lordship, kindly see our second paragraph, 55, starting page, 4 paragraph.
The affidavit replied that deponent excused that the petitioner's claim for completion of rationalization process is not based on facts. Her claim is reportedly based on a RTF report response from the PIO Office of the Child Development Project Officer Lala ICDS project. Here it is pointed out that as per records, the total numbers of Anganwadi centers approved for amalgamation is 36 in Lala ICDS project. But the Child Development Project Officer Lala ICDS project, in his letter, so and so rationalization dated 10/7/2024 has stated that total 32 Anganwadi centers have been amalgamated. Thus, 4 Anganwadi centers of Lala ICDS project are yet to be amalgamated. The deponent further submits that the para 4 of the government guidelines 15/6/2023 emphasizes that as and when a vacancy arises in any Anganwadi center within the same ICTS project, the voluntary service of the duly engaged Anganwadi workers of the helpers from the amalgamated centers may be placed with such center having vacancy. But out of 32 amalgamated Anganwadi centers, only 2 Anganwadi workers or 2 Anganwadi helpers have been absorbed in other Anganwadi centers. And still 30 Anganwadi workers and 24 Anganwadi helpers yet to be absorbed. Thus, it appears that the amalgamation, resolution of Anganwadi centers in Lala ICDS project not yet complete. So, record says. So that is the stand. And CDPO, my lord, he did not follow this notification also. This notification clearly says page 117.
So now when are you completing it?
My lord, today, my lord, I don't know, it is affidavit filed on, my lord,
April.
April. Perhaps, my lord, they have completed or not, my lord, I will have to open instruction regarding this. Without this, my lord, this notification 30 November 2023 says, my lord, the engagement so and so Anganwadi workers against the vacancy.
So there is no dispute that 32 has been completed. They have been amalgamated regarding 32 Anganwadi centers.
That is true.
But only 4 are left out.
4 are left out.
Now these 4, whether it would require amalgamation or not, is for you to decide and tell us.
No, absorption is also there, but out of 32 amalgamated Anganwadi centers, only 2 Anganwadi workers and 2 helpers have been absorbed. But they will have to absorb all these things, after amalgamation.
But absorb where?
These centers, amalgamated centers.
So when are you doing
local
it?
persons.
You have. Why did you float an advertisement without the amalgamation?
That is the CDPO method advertisement, without following the direction of this.
But that has not been cancelled.
It is not cancelled. Approval has not given.
Huh?
Not cancelled, my lord, but it approval has not given. Why approval has not given? That is the, my lord, regarding approval accorded for conducting interviews, the approval was conditional. The Child Development Project Officer Lala ICDS project was allowed to conduct interview as per advertisement published prior to amalgamation process of engagement of Anganwadi workers, helpers, by letter 29/8/2024. But the instant advertisement was issued on 4th March 2024. Whereas order of amalgamation was issued on 26th June 2023. As such, advertisement selection process does not come under the purview of approval accorded under letter 29/8/2024. So 29/8/2024 letter has to be produced. I think it is necessary. What is the contention of that? So without following that, CDPO published the advertisement.
17/6/2000.
Who represents the CDPO?
My lord,
Who is appearing for the CDPO?
see, I am appearing for it.
Then
That's why, this process. Let me have the concrete instruction regarding the completion of the amalgamation.
After filing 2 affidavits, one after another.
I will have to find out, the petitioners, they are who is Anganwadi center,
no, but their stand is that the amalgamation, 4 centers have not been amalgamated.
not amalgamated.
My lord,
Therefore, within that,
these centers, lordship, as per CDPO, lordship, it does not require for amalgamation. That's why, lordship, he has stated that
Has the CDPO filed an affidavit?
no, CDPO has not filed.
Let the CDPO file an affidavit with regard to this. Third, Mr. M. Khan, Counsel for the Petitioner. Disputes before the court. non-issuance of appointment orders, the petitioners, despite selection process undertaken pursuant to the advertisement dated 4th of March 2024, issued by the CDPO Lala, the district of Lala ICDS project, district of Hailakandi. Stop. Mr. T.C. Sutia, appearing for the respondents, appearing for the respondents, has referred to the two affidavits filed by the director. Submit that the claim of the petitioners for appointment cannot be undertaken prior to the rationalization process, which was initiated prior to the advertisement in respect of the Anganwadi centers. So, Mr. Khan, on the other end, on the basis of reply received from the office of the CDPO ICDS, Lala ICDS, replies from Lala ICDS
Lala ICDS.
that amalgamation process has been completed in respect of 32 centers and only 4 centers were left out, and no amalgamation necessary. Four centers have been left out, but only 4 persons pursuant to the selection have joined in their places of posting. Rest of the selectees have not yet been permitted to join. So there appears to be a difference in the stand reflected by the director, social welfare department, as also and the ICDS CDPO of Lala ICDS project. So although the director has filed their affidavit, CDPO has not yet filed the affidavit. The CDPO Lala ICDS project is permitted to file the affidavit within a period of 3 weeks. Let this matter be pulled up after 3 weeks. Let the affidavit come. Let the affidavit be filed. Then you make a mention. Yes.
Basically, we are challenging a order which I was not been considered for promotion. And there are few levels of to be promoted: A1, A2, A3, and A4. Initially, my entry into service was junior assistant wigman. Junior assistant wigman in the OMC mine. So it is, if you see at page 23, will kindly see at page 23. This is my appointment order, 26th of February 2015. Lordship got it, man. Please see 3 lines. So and so from 2014 for the post of A1 level. Lordship got it. Now, please see after completion of my probation at page 26. I completed my probation. Then why not? They came with a modified recruitment promotion regulation at page 27. Because initially eligibility criteria only eligible 6 years from going to A1 to A2, A2, A3, A4. Now they changed it by an office order at page 27. And for convenience of the court, we have given a chart. If your lordship looks at page 7 for the convenience of the court, may your lordship looks the chart, my lord, at page 7. It is the 5, if you see at 5, initially this was the eligibility. Initially in 2004, my lord. Lordship got it, my lord. This is A1. 6 years.
This is for
A2.
which post?
This is post junior assistant rigman. SMS is a grade 3. Now the nomenclature was changed. Later on I'll show this chart. Now if you please go down, please see go down. Eligibility years, it was modified. In 2020, it was modified. And now if you see at page 8, now A1 it is 4 years, A2 is 4 years, A3 is 4 years, A4 is 6 years. Now thereafter, please look into a bit down. See the old designation, junior assistant rigman, when I initially entered. Subsequently, it was in 2020, the designation was changed. Got it, my lord? So there is a chart for the convenience of the code. I made a chart. Now please turn to again page 27.
Page
27 now. 27. Designation changed. Eligibility criteria changed, my lord. Thereafter, this was modified in 2020. So I have made a chart. Now the chart, it has page 28. I don't have to trouble now because already I have indicated how that change was made by this modified. Now please see 34. There was an enquiry which was done against me. Now that enquiry was concluded and I have given a reply. After reply, there was an order which was passed by authority at page 40. Please see 40 minor. Departmental proceeding initiated, reply was filed. Thereafter, an order was passed on 9/10/2019. And if you see at 3 minor, whereas taking into consideration the charges level against the employee and the reply submitted, undersigned has come to the conclusion, end of justice would be met by imposing a penalty reduction to 1 stage lower in the scale of pay for a period from 1/10/2019 to 30/9/2020. During, please mark this, during the period of reduction, so and so, that is the petitioner, will not earn increment, and on expiry of such period, reduction will not have effect of postponing future increment of his pay. So this is what has been done. We challenged, but ultimately it was dismissed. Appeal dismissed at 41. That is not an issue before the court. Now please see page 44. Why I came before this court, man. Please see 44. This is absolutely no problem in page 44. Then, my lord, your lordship knows I have given a chart. 2025, they modified from 6 years to 4 years. From A1 to A2, now you need 4 years. Once I, my lord, my penalty was over, major penalty, that which was reduction in worst stage, one stage was lower, that is for a period of 1 year.
What is the punishment again?
Now punishment is for this major penalty under the discipline, and that punishment is at page 40. Please see 40 minus. Once again, please see 40. 40.
Reduction
Pay scale was reduced.
The pay scale.
Only pay scale. Pay scale.
Yes.
But once the period was over, my lord, then I was taken into consideration to the next level. Please see at page 44. If it's 24/12/2021. To the next level is A2. Now I was promoted, my lord. But here what ONC, my lord, it is only counted from January itself. Though my promotion was before that, but it will be counted from beginning of January. So it is 1/1/2021. If your lordship looks into the office order, please see the office order at page 44, my lord, where I was promoted. So and so employed to the post of deputy technician drilling A2 level, the pay scale with effect from 1/1/2020. Got it, my lord. At page 44, 3 lines. First 3 lines where I have been promoted. Please see, my lord, with effect from 1/1/2021. Got it? 1. Now, A1 to A2 I was promoted. Now, my name appears at page 48. Please see 48, my 99. 99.
99.
Lordship got it?
Okay.
99. Now, please see, by the time, my lord, an office memorandum issued by Ministry of Finance at page 52. Please look into it, page 52, which is 29th of July 2024. Lordship got it?
Hmm.
Now, if your lordship turn to page 56, see 4.2. This is Ministry, my lord, of Finance. Please see 4.2 at page 56. Vigilance clearance will not normally be granted for a period of 3 years after the currency of the punishment if a minor penalty has been imposed on an officer. In case of imposition of a major penalty, vigilance clearance will not normally be granted for a period of 5 years after the currency of punishment.
So your punishment is minor,
My is major.
major.
It is 5 years. My lord, this, now what happened thereafter? Page 59. Please look into page 59. This was a promotion which was due to me. Now this is A2 to A3. If your lordship kindly see, the order is 23/2025. My promotion was not reflected. Here my promotion was not considered. Now I made an email to them. Why it is not been considered? At page 64. Please see, my lord. After 4 paragraphs, after 3 paragraphs, now I would like to know the actual reason why my promotion to A3 level with effect from 1/1/2025 has not yet been released. Right? Now please turn to page 65. The reasoning is this, my lord, at page 65, which is impugned. As per record in so and so penalty order number so and so, major penalty and reduction to lower stage in the scale of a period from 1/10/2019 to 30/9/2020 has been imposed on you. Accordingly, as per clause 15 para 4.2, which I read at page 68, clear vigilance clearance was not granted, hence you had not been promoted with effect from 1/1/2020. So I am before this honorable court with this, my lord, because I'm aggrieved by the action which they have taken, where they said that your major penalty, your penalty will be over only after 5 years. Now, my argument will be twofold. Please look into my promotion penalty. Penalty is when? Please, I'll trouble your lordship with place 40, my lord. Please look into place 40. It is period 1/10/2019 to 30/9/2020. Now, my lord, I was promoted thereafter, your lordship has seen, with effect from 1/1/2021. When this change or modification of their order, which it was 6 years, they made it 4 years. In the meantime, I was promoted on 1/1/2020. This is my argument, core argument. Now, your office memorandum, ministry level of memorandum is of 2024. My lord, 2024, 4.2 indicated in that minor penalty and major penalty. Now, what they are saying, my lord, they are now going back again to page 40. They are going back again to page 40 and they are saying, giving a retrospective effect of that office memorandum of 2020. Now, my question and answer that it is not permissible. Their answer in the affidavit, yes, it is permissible with retrospective effect. My answer will be.
First, let us understand.
Yes.
The effect of the promotion, the effect of the punishment is till 30/9/2020.
Correct. Right.
So from 1st of October 2020, you are not getting a vigilance clearance for 5 years as per the.
No, that's they say. They are saying your 2024 office memorandum will be applicable in your case.
24 memorandum.
That is 2024 memorandum.
Okay.
Which at 52. Their case is that your office memorandum, 29 of July 2024 will be applicable.
This memorandum says what?
This memorandum kindly see if it is minor penalty and major penalty. And now please see page 56. Once again, page 56. That's a core
This
issue,
is for 5 years. So
it
this
is for 5 years.
5 years is with effect from 29 July 24.
If it is from the date when this was, my lord, issued, my case will be, yes, you can. but only it will be counted, not retrospectively, it will be counted prospectively.
Now, prior to 29 July 24, what was the position?
There was no office, no nothing, my lord. No vigilance care, nothing. I was, no, my lord will kindly see. My lord, I was promoted.
Your promotion is due. Your promotion is due
On
in 25.
1/1/2025. Now, my lord, if that be the case, if some office memorandum would have been there, I would not have been promoted in 1/1/2024 from A1 to A2. Am I clear, my lord?
Yes.
I would not have been promoted from A1 to A2. You have promoted me from A1 to A2. Now, next promotion comes A2 to A3 now. Now you are relying on
A1 to A2 is how many years?
I'm sorry, my lord.
A1 to A2.
4 years.
4
By
years.
modification of 2020, 4 years.
4 years.
Yes.
And these 4 years was completed in the year?
20,
as far as you are concerned?
my lord, that A1
24.
to A2. 24.
24.
21, sorry, my lord, 21.
Okay.
If you see at 21, at page 44, A1 to A2, this is my promotion
So you
order.
were promoted in 21.
21, I am promoted from A1
So
to
the
A2.
next promotion would be another 5 years.
25. 1
4 years.
4 years. Now they said, no, you cannot be promoted because your vigilance clearance is for 5 years. Now they are going back again to that minor penalty of 2020 minor, where your lordship at page 40. I say that how can you do it? Because I have been promoted.
So, but on the day you were promoted, this office memorandum was not there.
Not there. You came in subsequently. Can you give a retrospective effect?
No.
No, that office memorandum was not there.
Flip side of your argument.
Yes.
This office memorandum is effective from 29th of July 2024.
Right.
So if you get a promotion on 28th of July 24, you are through. If you are eligible for promotion,
No, my lord, what I am saying that this office memorandum cannot be applicable in my case.
why?
Why? Because what they have done, my lord, can you now go back to the order of 2019 at page 40, saying that 5 years is applicable on that particular day where penalty was inflicted to you? Please see, my lord, my order whereby penalty was on 9/10/2019. At this particular, if you see, please see again at page 40, my lord. Please see 40.
Yes.
Now, if you see the date with effect from 1/10/2019 to 30/9/2020.
So you are saying that this clause of 4.2
Yes.
will be applicable for those candidates against whom the penalty is imposed with effect from 29 July.
Correct.
And thereafter.
That's my case. It's a better way your lordship had expressed. That's what my case is.
So those people who had been imposed penalty would not be covered.
Yes.
Prior to this.
That's my case, whole case. That's my case. Now, my lord, one again. Now, please see at page 155 of the writ petition. Now, ministry, my lord, your lordship has seen in 2024. And at 155, please see that issued by the ONGC 28/2025. Lordship got it, my lord? Now, if your lordship looks into on top, ONC boards in his 397 meeting held on so and so approved the amendment of modified recruitment so and so. In accordance with the approval of what a new clause 713A is hereby inserted, Malafide may establish penalty has been imposed against an employee so and so, misconduct so and so. Now, whereas any minor penalty, please mark this, or major penalty except a penalty of compulsory retirement, removal of service or dismissal service as specified at Rule 34 has been imposed for misconduct and so for a concerned employee shall not be eligible, please mark it, for promotion for 3 years in case of minor penalties and 5 years in case of major penalty after currency of the penalty. My lord, now please see 5. The provisions of the new clause
and mentioned in para 2 shall be applicable for all promotion to be considered after issuance of this OM. So now, only after issuance of this OM, if any penalty, minor or major, if penalty is inflicted to any of the employee, it will run from this date. So my penalty, you cannot take my penalty and you count from that day. Now, my lord, what they have done, a further modification they have brought by way of amendment of that 2024. I sought leave from this court to file an additional affidavit which the court has allowed. Now, please, I'll trouble your lordship with this additional affidavit. If your lordship looks into my additional affidavit at page 199. 199. Lordship got it, man? 199. 199. This is of 22nd of July 2025. Now, please see the first, after that, of serial number 15. Department of Public Enterprise earlier issued consolidated and revised guidelines regarding vigilance policy, wide OM of event number dated 29th of July 2020. That's page 52, my lord, which I have shown. The lordship can check the date. That's what 4.2. Followed by a coordination dated 13 November 2024. However, in the light of Department of Personnel and Training DOPT dated 9th October 2024, certain provisions of DP guidelines require further modification. Accordingly, with the approval of the competent authority, the guidelines are further consolidated and revised as follows. Now, if your lordship now turn to page 204, how they have changed and modified. 204. 4. Kindly see residual issues. 4.1. Vigilance clearance shall be denied to an officer if he failed to submit his annual immovable property return of the previous year, latest by 31st of January of the following year. 4.2. Vigilance clearance will not normally be granted for a period of 3 years after the currency of the punishment if a minor penalty has been imposed on an officer. In case of a imposition of a major penalty, vigilance clearance will not normally be granted for a period of 5 years after the currency of the punishment. During the period, performance of the officer should be closely watched. 4.3. Any reference to vigilance clearance, the aforesaid subpara, namely 4.1 and 4.2, will mean vigilance clearance with respect to A, B, please see A, B, C, D, E, F, G, H. So now promotion has been deleted from 4.2. Only your vigilance clearance will be confinement only to this A to H. I don't fall under this matter. My argument will not, because this is not, I brought notice to the, now their averment, they are saying that you have suppressed the material fact in one of the paragraphs saying that you have been promoted. My promotion has been taken place. You have given promotion in 2026. My promotion, which has been given in 2026. What I am saying, my promotion should be immediately after 4 years to A3, which is due on 1/1/2025. So, my lord, my argument boils down to 3 issues. One is that, number one, my penalty was in 2019, which is ending in 2020. This is one. My promotion, that time, the office circular was not in existence. It was not born. Now, I was promoted in 1/1/2024 in 2021. That is 2021, 1/1/2021, after completion of 4 years. Now, my next promotion was 1/1/2025. In the meantime, I was not considered for promotion. I wrote a mail to you why my case is not been considered. Now, the reply is that your case could not be considered because of 4.2 of 2024 of the office memorandum notification, which is issued by the ministry.
This is their case. So you are covered. Then you are going back again to that. So this is my case is that you cannot bring back that office memorandum because that office memorandum is subsequent in 2020. If any penalty have occurred on that particular date thereafter, then of course, that will cover. It doesn't cover. That's our case. And they adopted in 2025. Your Lordship has seen that. ONC have adopted only in 2025.
Where is that?
Where your Lordship will find at page, please see at page 155. 155 of my writ petition. 28 2025. SC pack 5, my lord. C5. The provisions of the new clause as mentioned in at para 2 shall be applicable for all promotion to be considered after issuance of this order. So they mention in paragraph 2, my lord, regarding major penalty and minor penalties. If your lordship see as paragraph 2, my lord. Whereas any minor penalty or major penalty except the penalty compulsory has been imposed, misconduct so and so concerned employee shall not be eligible for promotion in case of minor and 5 years in case of major penalty after the currency of the penalty. My lord, they want to keep inconsistence with that 2024 office memorandum, that notification from ministry. But they are saying 5, my lord, the provisions of the new clause as mentioned shall be applicable for all promotion returns after issuance of this OM. Basically, it doesn't cover. So where is that you are withholding my promotion on 1/1/2025 on the ground that you are covered by a notification of 2020? That's my case. So they should consider my case. I'll give a reply.
Yes, Mr. Chaudhary.
And there are some dates which will be available. If your my learned friend has already placed page 40, the lordship may just make a note of the dates. The period of the penalty is 1st of October. If your lordship will kindly come back to page 40. Yes. Paragraph 3, right in the middle in bold letters, reduction to one stage lower in the scale of pay for the period from 1/10/2019 to 39/2020. This date is relevant, madam. 39/2020. Now, the petitioner got his first promotion from A1 to A2 on 24/12/2021, when the Government of India's Ministry of Public Enterprises, that OM was not in existence. So therefore, he got the promotion. Now, on 29/7/2024 is the date on which the Government of India issued the instruction. If your lordship, there is one relevant portion that I would like to point out. If your lordship comes to page 52, lordship will have a look at the subject. This is exclusively meant for the central public sector enterprises. Consolidated and revised guidelines regarding vigilance policy for CPSEs. This question of adoption, non-adoption would not even arise, but I will point out to your lordship that it was in fact even adopted. Now, if your lordship will kindly come to page 68. This is the ONGC's own conduct, discipline and appeal rules, 1994. Yes. And if your lordship kindly turns to page 150, it's a very voluminous document. First, your lordship may kindly, no one is disputing it, but I would like to show that the penalty imposed was in fact a major penalty, which your lordship will find from page 105. Under the heading major penalties at serial number small Roman 8, your lordship will find that reduction to a lower stage in the pay scale amounts to a major penalty. Now, if your lordship kindly turns to page 150, 150. So, based on this OM dated 29/7/2024 of the Government of India, at page 150, your lordship will find right at the bottom our own discipline, conduct and appeal rules were amended. Right at the bottom in the chart, your lordship will find, in case of imposition of major penalty, vigilance clearance will not normally be granted for a period of 5 years after the currency. Your lordship will kindly note this.
This amendment came in which year?
I will give your lordship the exact date. We have even stated it in the affidavit. This amendment was made on 2/9/2024. This date is very important.
9/24.
2/9/2024. This is stated at paragraph 6 of our additional affidavit, reply to the additional affidavit at page 210.
2/9.
2/9/2024.
Yes.
So, this Government of India OM comes on 29/7/2024. We carry out the amendment in our discipline and appeal rules on 2/9/2024, and the consideration for promotion is dated 20th of March 2025. This page 155 that was pointed out by my learned friend pertains to a completely different set of rules. Your lordship will kindly come back to page 155. This is a...
But assuming it is amended on 2/9/24, then also this 5-year will be applicable for those who have been imposed the major penalty on or after 2/9/24.
No, that is with respect to the promotion. That is a different set of rules. Here, if your lordship kindly comes back to
150.
150.
150 is your rules.
Yes.
Where you have amended in the same lines, say that 5 years moratorium.
5 years from the
period you complete.
From the period. So the completion, date of completion is 30th of September 2020.
Right.
So the clock will start ticking so far as that 5 years is concerned.
From when?
From 1/10/2020.
How? Because your amendment is on 2/9/24.
24, yes.
It doesn't say it is retrospective.
No. Now here is a, let us forget this issue.
Can either say that it is retrospective and it starts from that period.
But let me make the position clear. Assuming I am holding a post of executive, there is a set of rules which is governing me. At the time of right before the time of consideration of my promotion, the rules are changed. Will that rule not be applicable to me?
It is.
Yeah.
But question of this puts an embargo for 5 years.
Yes.
From the time you complete your punishment. The person completed his punishment on 110, let us say. From 1/10/24, it will continue for 5 years.
On 30th of, anyway.
110.
110. So from 110, we will have to count 5 years.
No. So this particular rule was not there on 110.
No. On 1/10/2020, it was not there. But before he became due for promotion. There is an amendment carried out to the rule.
Then how do you carry it back to 110/21?
It is that retrospective.
You can say that in view of this, that you'll have to wait for another 5 years from 24.
No, not 24. We are saying you will have to wait from the date on which you completed, because the rule says that for a period of 5 years from the.
So therefore, it will mean that this particular
That-
amendment has been given a retrospective effect.
No, that is where I respectfully want to differ on this point with my learned friend. The retrospectivity is not with regard to the penalty itself. The retrospectivity is with regard to the consideration for promotion. So, are we giving retrospective effect to the consideration for promotion? No. What we are saying is your penalty is completed on 30th of 1st of October. With effect from 1st of October, 5 years you have to complete before you will get the vigilance clearance. It is not doing anything to his penalty. Because the government of India has put an embargo on us, and your lordship will kindly have a look. The reason is this one. That is why we need to go a little further, deeper into the facts. If your lordship will kindly first come to the show cause notice matter for a moment.
All right, we'll carry on.
Yes, this will require some further facts to be placed.
Yes.
Just this particular week, entire week, I'm away, my lord. Any other date convenient?
Therefore, we can't be partnered. What is the point in partnered if you're not available?
No, next Tuesday.
Next Tuesday is fine.
Next Tuesday.
Okay.
Next Tuesday, I'm available.
Next Tuesday.
Next Tuesday or next Thursday, I'm.
Let it be next Tuesday.
Just the week after that, my lord, entire week, I have
Next
to be in
Tuesday.
Arunachal.
Ninth.
Ninth.
Right.
9th, I'm here.
Further hearing.
Yes.
Ninth.
Item
Third in
number
part.
45.
45.
Can it be on the 16th of July?
Five. 16.
My lord, I have 40 and 41, my lord. In this case, my lord, I have to produce record and some translation regarding separate proceeding, my lord. So it is already I've done, my lord. On next case, my lord, I'm 2 weeks, I will not be available. So I on date may fix, my lord. My learned friend also agree, my lord. 16th July, my lord, if possible.
16 July.
16th.
And 21st July.
21st July, my lord. I'm in out of station. 16, my lord.
Not 16. 23rd.
23rd.
23rd July, item number 40.
My lord, I think 47 and 48. Very urgent matter, it was had long back. And it may kindly be listed on Tuesday, man.
All right, Tuesday.
47 and 48.
47, 48.
Yes.
Is that jurisdiction?
Yes. No. It is absorption
From deputation.
Deputy. 47, 48. Still on.
Lordship, item number 39.
Yes.
There was an interim order.
Item 39. Be listed again after.
Tuesday coming week. There is an
Everything can be on Tuesday.
interim Thursday.
22nd.
There is an interim operating there. Transfer matter.
22nd.
Last week we are not giving anything for hearing because it's the motion week.
Coming Thursday.
18th.
All right, 18. Interim order passed earlier.
Much obliged.
Please, your lordship. Item number 44, you know. Maybe listed next
Tuesday.
next week, any date, your lordship. At
Thursday.
Deep
Deep
level.
11.
Deep level.
Item number 54.
Get some date from the court master. What date? You want a long hearing. We can't give you a long hearing. So many matters are there. So before vacation is not possible. You come back after vacation. 21st July. It is urgent, but you need 1 hour, 2 hours. So we can't give you 2 hours for one matter. In a list where we have 40, 50 matters.
One hour.
That's right, 1 hour. We'll have to fix a date on as per our board. Before the holidays, it is not possible. We have a 21st. We'll hear only your matter. 21st July. Yes. 21st.